Williams, you know that we need to finish early.
Yes.
3:30 should be the target.
Very good.
3:45 absolute limit. The other thing is, given that we've got a 3-hour session, or just about a 3-hour session this morning, at about halfway through, could we find a convenient moment just to break for 5 minutes?
Certainly, of course.
Obviously, we've read the papers, we've read your skeletons and very helpful submissions. Did you receive a copy of the report? Which
we did, thank you.
I wonder if it might just be helpful if I just said something about a vague indication of where we are.
Certainly, thank you.
Certainly my understanding is that at this level, if a previous decision of the Court of Appeal is per incuriam, we're bound by it. That doesn't give us a sort of get out of jail card even if we wanted to. So the first question, as it seems to us, is what is the ratio of Aldred? And although the question of interpreters as such did not arise in Aldred, our provisional view is that we need to look carefully at the reasoning that underlay the introduction of things.
Yes. If
the ratio is that features that are a personal characteristic of one of the people involved are excluded from age, and if that is binding on us, then it seems to us the question shifts to whether the landscape has altered sufficiently to permit or require a different interpretation given the new terms of the overriding objective and PD1A. Given that no one saw fit, despite the prod, to change the terms of H itself. So that is a very vague and general indication of what we've been discussing and where we think we might be more or less at the moment. Having said that, don't let me interrupt the flow of your submissions as you plan them. We also think that it is likely to be absolutely necessary, and it may be that the best way to do this is for you to provide an agreed note after of the chronology. So the basic chronology is rules, Aldred, permission refused with rider, the committee look at it, report produced yesterday. The rules committee then introduce, I think it's the 127th update to practice directions, and change the words of the overriding objective. And then that brings us to where we are now, as it seems to us.
Yes.
I think it would be very helpful if, to avoid any misunderstanding, it need not be detailed, but we could just have a chronology.
Sort of timeline.
A timeline.
Yes.
And I don't know that we've all had the opportunity to do this, but we collectively have looked at the report and can see what it does and doesn't have.
Yes, indeed. Well, I'm obliged for that, and of course we'll collaborate on a note of that sort, chronology of that sort.
That's all we need to do. Yeah. Okay.
Thank you. Well, my lord, my lady, my lords and my lady, just before I get into my submission, I could just discharge the traditional courtesy of introducing my learned friends. I appear with Mr. Shannon Eastwood. My learned friend, Mr. Simon Brown, King's Counsel, appears for the respondent.
Thank you.
Now, so far as the points which your lordship has put to just summarised, if I may respectfully say so very helpfully, obviously I can see that a close focus is needed on the ratio of Cham and Aldred, because it's a somewhat unusual situation. In that what we appear to be confronted with is a case which is obviously not concerned with what this case is concerned. It's concerned with the fees of counsel on a child settlement opinion. But the reasoning which underpins the court's conclusion that disbursement could not be recovered, as Lord Justice Coulson says in a passage which clearly is obiter, nevertheless appears to lead inexorably to the conclusion that the disbursement, which is the feature of this case, wouldn't be recoverable either, and I acknowledge that. Right. So are they what Lord Justice called Lord Justice? Sorry, did I interrupt you?
No, there was noises off at this.
Noises off. So are they Lord Justice Coulson that his specific remark about interpreters must be obiter because because there wasn't an interpretation fee in that case. The core of his primary reason for dismissing the claim for the barrister's fee for the infant advice, the 4529I 82H doesn't allow disbursements which are a result from a characteristic of the claimant.
Let's just call it H. Let's just call it H for. It'll save us about half an hour.
It will, yes, in aggregate. Yes, I quite accept that the reasoning which underpins the ratio of the decision appears to apply, as Lord Justice Coulson observed, obiter seamlessly to the disbursement which is the subject of this case, because it flows on Lord Justice Coulson's analysis from a characteristic of the claimant. Now, there are multiple respects in which I would respectfully critique Lord Justice Coulson's analysis, because, for example, we don't see why a characteristic of a claimant isn't a characteristic of a dispute. But obviously, I recognise that the freedom with which I can impeach the Lord Justice's reasoning when it's part of the ratio at this case is at this level is close to zero. Unless I can either show the caravan has moved on, which is the second point that your lordship put to me, or I think it probably is right to say that within the Young and Bristol aeroplane exceptions, there is the ability to say that a decision isn't binding because some sort of fairly fundamental point hasn't been addressed. And here we would obviously say the points about discrimination, for example, which didn't arise on the facts of Aldred because it was a case about a barrister's fee. But we say are very clearly engaged in a case such as this, and so there's a whole raft of arguments which Lord Justice Coulson didn't hear and didn't need to think about because they simply didn't arise out of the facts of that case. But if the court takes a more austere approach than that, and takes the view that even if there was an essential line of argument which didn't manifest itself because it didn't need to, then I suppose the most I can do, if I don't persuade you the caravan has moved on, is to invite the court to apply the ratio, but to give permission to appeal.
I mean, speaking for myself, I think it would be quite useful if we did traverse over that ground a little bit to see what flexibility, brackets, if any, close brackets, we would have if as you say, a fundamental line of a line of authority was not relevant to the previous Court of Appeal, which might therefore give some flexibility to depart from.
Yes. Well, I'm very conscious and became conscious overnight that we don't have Young and Bristol aeroplane, for example, in the authority bundle, and we probably ought to, because there are issues here clearly about precedent and the freedom with which this court can operate. If this court is troubled by the precedent, obviously I don't want to be presumptuous and assume that the court will be troubled by the precedent. So perhaps that's something that we need to.
If by that you mean the precedent of Aldred, we are definitely troubled by it.
Yes.
Because unless and until you distinguish interpreters on the facts, or you demonstrate that we're not bound by it, as you have said, the ratio applies to the present case.
Yes.
Which is not to give any indication of where we would be going if it didn't. No, it's just we've got to. That's the starting point.
Well, I'm grateful. So,
and just to be clear, just so I can ask as well, speaking for myself, but certainly it would be useful at some point. I expect you will do this. Is to outline the economic effect of the regime that we're dealing with and how, for example, interpreters fit within it.
Yes.
Compared to barristers' fees, for example. So, because I'm certainly very conscious looking at the papers that there are broader economic factors at play here, which wouldn't normally be for a court to decide, because it's not for the court to decide how to pitch the economies as between parties. That's for the Rules Committee.
Yes.
But it's plainly something that's going on in this sphere.
Yes. Yes. Well, I should. As I come to section 3A of Part 45, I'll do my best to keep that in mind. But certainly, we say the thrust of CPR 40 of the relevant fixed cost provision is to control what lawyers can charge for the provision of legal services, and that's the alternative aspect that the issue 2 in the Cham case that Lord Justice Coulson also finds the defendant on, where he says, well, you can't claim this because this is essentially a routine fee of a legal nature, and it therefore has to be taken to be assimilated already within the actual fixed costs, which are what the lawyers get.
And he did that in the slightly odd context that whereas interpreters are not mentioned at all, council's fees, and specifically council's fees for a child settlement opinion, do feature expressly in some, not consistently, but in some of the, in part 2, but not part 3, I think it is.
That's correct. Yes, yes. And he draws some. I think he draws some affirmation from.
But that would go to the question whether, by implication, interpreters' fees are in the fixed fee.
Well, I'm certainly coming and also attempting to presage what I'd say in response to my Lord Justice Snowden's inquiry, drawing the distinction between that which can be assumed to be wrapped into the fixed fee, which is, I would say, the supply of professional legal services, and what you have within disbursements, which are very often not legal services. Obviously, most commonly they're court fees, experts' fees, things of that sort in personal injury cases. And we would obviously say, well, the fees of interpreter or translator, they are not part of the suite of services which you expect a solicitor to supply. And although my learned friend, for example, says in his skeleton, well, on an ad hoc basis, there'll be some firms of solicitors that do have multilingual fee earners, and they, for example, can translate witness statements. I mean, to suggest, however, that is a mainstream legal service which a firm of solicitors can be expected to be able to provide across the broad spectrum of languages which are now spoken in this country, particularly in its large cities. And to say nothing of actually sending somebody to court to act as a translator.
Well, but on that, just again for me, I think there may be a distinction between providing in-house translation services when doing preparatory work, and, for example, just taking instructions from a client. You know, it's part of mainstream legal services if that's the market you're operating in, and indeed selling yourself perhaps as a law firm that has that multilingual facility. But when it comes to actually a trial, I'm not entirely sure that it would be appropriate for an in-house translator at the claimant's law firm, for example, to be acting as interpreter, even though they have to take an oath. I think there might be some objection to that at a trial. I thought that at a trial, certainly in my experience, interpreters in the criminal courts, for example, are not supplied directly by a law firm. They are independent.
Yes. Well, in fact, in one of the documents, there is one document which we are proposing to add to the bundle with apologies. It is, in fact, the directions order that was made in this case by His Honour Judge Freeland QC, who actually specified that the interpreter at trial had to be independent and suitably qualified. So just having a bilingual fee earner within the law firm would clearly not have discharged that direction.
That's why you sent it to us.
That's why we sent it to us. I didn't know it had been sent to you, so I'm glad for that. Yes, it's.
We got that yesterday, I think, by email.
I'm grateful. Well, I'm grateful to. I dare say that was Mr. Eastwood behind me, so I'm grateful to him for that. Yes, that is why that has been added, and it's the second page. It's paragraph 4D. If a witness who has made a statement is to give evidence or be cross-examined and is unable to do so in spoken English by reason of English not being their primary language, or Welsh if the hearing is in Wales, the party relying on that witness must ensure that a suitable independent interpreter is available. It is the responsibility of the respective party's solicitor to ensure that a suitably qualified independent interpreter is available at trial.
I don't seem to have got that by email. It may not matter very much, but if you had a copy, it would solve the problem.
Would a hard copy assist anyone else on the bench?
I seem to have one in my. There's some documents being put on the bench, at least for me.
I just sent it to you in case you wanted to have it. I just sent it to you.
Thank you. Okay, thanks very much. That's very helpful. No, I didn't have it. Thank you.
And also, Mr. Eastwood reminds me, I referred to 4D, but 4C also specifies that an accredited translator also needs to be deployed in respect of the witness statement. And that's actually subject to a debarring sanction. And I would also I can't as it were sort of give evidence that this is the position, but I would certainly infer that this is a standard direction that's used in multiple courts, because the reference to if the hearing takes place in Wales is obviously not something you would expect to be in an order if it was bespoke to the Central London County Court.
It doesn't come as any surprise to me that it would not be appropriate to have an in-house interpreter
Yes.
when somebody is giving
Yes.
live evidence, unless both parties agreed that it was the only feasible way to achieve it. If it was a particularly, rare language, for example, that was spoken, and the numbers of people who could act as interpreters were very, very,
very small. Yes, I mean, clearly there are firms of solicitors that service the large language groups, if I could call that Polish, for example. But certainly there are. We all know how many languages are spoken, for example, in parts of this city nowadays. There certainly won't necessarily be a large range of solicitors that would be able to discharge that, even if they were entitled to. But specifically, my lord, in answer to your question about the economics, that's really the point I would make about the economics. And it's also a riposte to one of the points my learned friend takes, which is that to suggest that this is just wrapped up into the fixed fee for the solicitor, when it is by its nature an external expertise not of a legal nature, which has to be brought in from somebody independent. It's just, in our respectful submission, completely unconvincing to say, oh, all this has already been catered for within the fixed cost provision. And it's equally unconvincing to say that there are swings and roundabouts, as my learned friend says, because, of course, in some cases there'll be swings and roundabouts because the costs are fixed and you get the same, although the case settles at the beginning of the relevant period or the end of the relevant period. And you can see there are swings and roundabouts. Some case you'll get too much, some case you'll get too little.
Well, I think he says, and I'm conscious we don't want to get out of your sequence of argument,
no.
But I think it said, look, if you're a solicitor operating in this area, you win some, you lose some. And if you can foresee, as you will have to, that if you take on a client who's going to need an interpreter at trial, if that comes out of your fixed costs for that particular trial and the case actually does go to trial or sufficiently close to it, you need to engage the services of an interpreter in a particular case. That's just maybe one of the ones you lose, and in another case you'll win, and it's just part of the overall exercise that a law firm engages on in deciding to do this type of work in this type of field. Yeah,
well, my lord, I see that, but of course the riposte to that would be that is to presuppose for there to be winning cases and losing cases, that the fixed fee for the legal work contains an element for interpretation work that therefore overcompensates the solicitor in cases where there's no need for an interpreter. But that we would respectfully suggest is an obviously false premise. Why would a fixed fee for legal work contain provision for translation work which is not legal work and which has to be provided by an independent third party? Precisely the sort which is characteristically a disbursement in circumstances where the regime does apply for disbursements to be allowed separately from the provision for the lawyer's professional charges. So that's where we would say any logic to that effect would break down, because it's falsely premised. There is nothing.
You could make the same argument, in fact, in relation to a child and disbursements for a counsel's opinion for a child.
Well, that is less clear because the fixed fee provision is for a professional legal service. Firstly, lots of firms. This only applies to mostly simple cases, straightforward cases with relatively low value. So lots of solicitor firms, in fact, would perfectly well have the internal expertise to write a note for the court where they cite a few cases from Kemp and Kemp or whatever it may be and say this looks like a reasonable settlement. So I wouldn't accept that you can assimilate a completely non-legal service like an independent translator with what might be thought to be part of the fixed fee provision. And the fixed fee provision is intended to generally cover counsel's fees, because, for example, it contains an advocate's fee for the trial, which is one of the points that Lord Justice Coulson.
Maybe I misunderstood, but I don't. Again, the same law firm. I thought the whole point about the counsel's opinion with the disbursements that was an issue in Cham was that it had to be from an independent counsel. You couldn't just have the solicitors themselves writing the opinion, could you?
I'm not myself aware of any reason why you couldn't. Yes.
You've also got the oddity that at least in section 3, under 4518 and Table 6, the fees for Council's opinion on a child settlement are expressly mentioned and expressly recoverable within the fixed fee structure, within the box.
Yes.
And at least in relation to 3, you therefore know that Council's opinion is not being treated as a separate disbursement, it's in the fixed fee. And you've still got the equivalent of H sitting for Section 3 cases.
You do, yes.
It's very odd. It's this inconsistency about the treatment of the children's opinion, which is odd.
Yes, well, of course, Section 3 applies to cases that are dealt with under this extremely abbreviated part, Stage 3 procedure, it's known, where you start under Part 8 and they're dealt with at court without any oral evidence or anything like that. So it's a very streamlined procedure. So what they seem to have done there is to actually prescribe the uplift that you get if the case involves a child. Now, they haven't done that separately in Section 3A, and I mean, that might be simply because Section 3A, because it potentially applies to more complicated cases. For example, Section 3A will apply to cases where liability is disputed. So one of the matters that will often arise in an infant approval under a Section 3A case is, well, that's although it might not seem like a very large amount of money, there's a discount because there was a dispute on liability, for example. So it is rather more complicated. And so it's subject to the problem, if I can not disrespectfully call it that of Cham. We would say the explanation for the difference is that whereas in Section 3A you can really have a sort of one-size-fits-all prescription, that's what you get if there's an infant approval. At Section 3A, we said that was simply left at the discretion of the court to allow a disbursement because of a particular feature of the dispute, until, with the greatest respect, Lord Justice Coulson queered the pitch. You'll see that he differed from both the district judge and the circuit judge in the lower court, who were applying...
I'm not sure that's a phrase that's going to appear in any judgment, really.
Well, I did say with the greatest of respect, but if it wasn't...
It's an entirely technical use of the term. Yeah.
Right. So shall I? I've obviously been trying to deal with the court's inquiries, but just to try therefore to take it through in my sequence. Our case is subject to Cham, and if I can just address it without Cham before I come to Cham, we say that Cham aside, the recoverable cost of employing an interpreter should be, and we, as we would have it, is recoverable in fixed cost personal injury claims. It clearly is the position in all other cases where costs are recoverable, including other fast-track personal injury claims. There are not all fast-track personal injury claims fall within Section 3A because that only applies to and it applies to public liability, employers' liability, and road traffic accidents, but it doesn't apply, for example, to industrial disease cases and such like. So in all other fast-track personal injury cases, you can recover interpreters' charges. And we also now know, because Mr. Brown kindly circulated it on Monday, that from the 1st of October, the rules will also expressly provide that interpreters' costs are recoverable in cases like Mr. Santiago's. So from the 1st of October, there is going to be specific provision in the rules that say that in fast-track cases which have left these protocols and have been issued under Part 7, interpreters' fees will be recoverable. So it is a problem, and I don't know whether we need to add that to the timeline which you mentioned. It's a problem that there's a fix, if you can call it a fix, that is coming down the line towards us. So it's a particular issue.
It doesn't help you.
No, it doesn't help us.
It doesn't help you at all. Well, in two respects, it doesn't help you. One, it's not in time for you. But two, it contains at least the implicit indication that the Rules Committee don't think they've fixed it yet.
Well, I'm not quite sure about that because I mean it is part of a sort of complete overhaul of Part 45, which is not going to look which is really just going to look fundamentally different.
Sorry, I think I've
It's in the supplementary body.
I've missed this. Which is the supplementary.
Yes, so it should be. should be headed Index to Supplementary Authorities Bundle, which just contains two things. It's a 41-page filing, so it should be quite.
Okay, I've got three unlabelled blue bundles. Which one am I looking at? Am I going for the supplementary bundle for the appeal, the application bundle,
Supplementary
or
authorities bundle.
Can I ask, Mr. Do you know what it physically looks like? The hard copy bundle.
it's again,
Like a 41-page bundle.
But it wasn't my.
Shines a little white bundle. That's what
Yes. Do you happen to know what it looks
That's
like?
it. That's it.
Okay,
I think
okay,
that's
I've
it.
got a little
But
white
I
one.
haven't located it either within that bundle, so
You're referring to the draft for early publication, aren't you?
Yes. Okay.
Yes, yeah.
could we circle back and just find the document, please, that you're referring to, Mr. Williams?
Yes, indeed. So, I was slightly distracted because I was trying to find out what colour the file
I
might be.
think
Does the
it's
court
this
now
one.
have
It
one?
is. It's
I
this
am
one,
grateful. So
yeah.
the court does have it. So it's the draft part 45, which begins at page 4 of that document.
Yes, the bundle actually isn't page numbered, so you
Ah.
can just go on the internal.
I'll have to use the
pagination.
internal pagination, so be it. So my learned friend, I think perhaps not in a note the court has seen, but in a note I've seen, refers to section 4, Roman 4, which is at page 19 of the internal pagination. But that section actually isn't the relevant section because as you'll see 4527, this section applies to claims that have been or should have been started under Part 8 in accordance with Practice Direction 49F, the Stage 3 procedure. So this only applies, Section 4 only applies to cases which either aren't issued at all or settle within this extremely streamlined process within the protocol. So this is the equivalent in my Lord Justice Stuart-Smith's terminology a few moments ago to the old Section 3. So Section 4 that my learned friend referred me to doesn't apply to this case. This case would be a Section 6 case, and Section 6 begins at the first of page 27. I'm in slightly awkward because I've been using the
31.
PDFs. So Section 20. Section 6, this section applies to any claim which would normally be or is allocated to the fast track, which would be this sort of case, a personal injury case with a value of less than £25,000. And you'll see at 45.44, it's going to allow fixed costs in a table and disbursements as set out in Section 9. I'll come to Section 9 momentarily. Just to dispel any doubt that this section does apply to cases which have started under the pre-action protocols and then left it, you'll see at page 29, at 45.47, and the heading above it, there's express reference to this section applying to cases which were started under the Road Traffic Accident Protocol or the Employer's Liability Public Liability Protocol. So it's this section which would apply to a future Mr. Santiago bringing an otherwise identical claim. And so far then as Section 9 is concerned, again I'm just going to have to translate from that. So Section 9 begins at page 35 and it deals with Section 6 on the following page in Rule 45.59. And you'll see that it then there's a list of disbursements and added to it by any interpreters or translators' fees.
Can you just give me, you're on
Page 36.
36 of the internal pagination, 39 of the
39 of the PDF, yes.
and you're looking at 45.59.
Down at Roman 5, A Roman 5.
Yeah.
And this has also got a sweeping up provision like its predecessor, but the sweeping up provision is then differently phrased. So it drops the phrasing which Lord Justice Coulson was analysing in Cham. So at B, foot of the page, any other claim to which Section 6 applies, any disbursement which has been reasonably incurred other than a disbursement covering work for which costs are already allowed in Section 6. It's slightly circular, but again, that's...
So this is a limited duration issue.
This is a limited duration issue, albeit...
Post-Cham, up to, if they introduce this, that will solve your problem.
It will solve the problem for future claimants.
And what's the status of this? Is it just
this I think has been promulgated by the MOJ, but it's a draft. It comes into force on the first. The provisional date for it to come into force is the 1st of October. You have some summary at page 2 of the page 2 of the PDF. It's enclosure 1 of the hard copy. So it's subject to formal ratification by the CPRC and by the Master of the Rolls as Head of Civil Justice, and obviously ministerial concurrence and approval by Parliament. So these are proposed
changes.
Can I see?
Yes, because Mr. Brands.
I'm sorry. It's come as a surprise to the bench. The note on the second page of the introductory note says these papers are published in draft so stakeholders may have advance notice and more time to familiarise themselves with the new regime. So this is published only in the last few days, I think. That these are intended to be the rules, subject, of course, to enactment, but it's not for consultation, which is, sometimes people think these are for consultation, they're not. They're for familiarisation. It's what's coming in October the 1st, if all goes according to plan. Sorry, my lord, you were saying I spoke.
Thank you. So that is a complete reversal of Cham. Yeah.
Yes, so it is. It's a problem which is now being contained, if I can put it that way. But of course, there's a very substantial tell because these cases are very high in volume. And certainly in large cities, the number of cases, I think in cases like in this city, cases at places like central London and Clerkenwell and Shoreditch, the proportion of cases
quite a lot of these
interpreters are very high in number, which is why you see the learned circuit judges giving standard directions for translators and such like, because it's a problem that is probably, well, I perhaps shouldn't use loaded language like problems. It's a scenario which occurs.
It's very familiar.
Yes, constantly, daily.
And this is said to be further to a bulletin in 2022. I mean, does that contain any just? Was there a? I understand that these are said to be, what's coming down the track. But was there a sort of discussion document or a bulletin which identified the sort of range of issues that these changes were supposed to address?
Well, perhaps to put it into context, the answer is yes, there have been a number. And to put it into context, the primary focus of this reform is not fixing Cham and Aldred. The overwhelming focus of this approach is a massive extension of fixed costs, which is something which has been consulted on pretty regularly ever since the Jackson reports at the beginning of the last decade. So what these reforms do is they extend fixed costs to almost all fast-track cases rather than just a subset of personal injury fast-track cases. And they also create a new track, which is the intermediate track, which will fall between the fast-track and the multi-track. And that's got fixed cost rules as well, which will apply to cases of up to £100,000, I believe. And I mean, it's going to be absolute manna from heaven, one assumes, for the junior bar as these new provisions get sorted out, because you then have within the tracks complexity bands, to which cases fall into specific complexity bands, and the fixed costs will vary depending on which complexity band you fall into. So I don't want to, and perhaps this is the response to my Lord Justice Stuart-Smith sort of putting to me, oh well, doesn't this show that what you've previously got isn't sufficient to fix Cham? I mean, I'm not suggesting it explodes that proposition, but it would be a mischaracterization to see this as a reform that really has got much to do with Cham. It's an altogether bigger fish, if I can put it that way. I mean, this is a sort of complete overhaul.
But they have, as part of it,
yes,
addressed the question raised by this case.
Yes, and certainly that has been. I mean, if one looks at Civil Procedure Rule Committee minutes, there's been. It has to be said. It does seem to me as an outsider slightly desultory discussions of Cham and Aldred going on. Ever since it was decided, you see it sort of referenced in the minutes, and I think Lord Justice Burse or some other eminence is asked to prepare a paper on it, for the committee to consider and so on, and then. It hasn't previously led to a specifically targeted rule change of the sort which we can now see is coming down the line. But obviously, in foot with this, we've also had the more general reforms for what are broadly called vulnerable litigants, to which obviously, on which obviously I'm relying to say, well, if I can't massage Cham and Aldred, it's a reason for saying the law has moved on since it. So, can I just take as my starting point before I come to Cham and Aldred itself? Our proposition is it would seem extremely surprising if the rule makers had intended to deprive personal injury litigants in a subset of fast-track cases of the ability to recover the cost of an interpreter where the services of an interpreter are actually necessary, not least to discharge positive obligations under the rules of court. And the practice direction 32, contains detailed provision in respect of translation and interpretation when witness statements are prepared. And we've already seen the standard directions which the judges dealing with fast-track cases make for independent interpreters to attend court. The reason I suggest it would be very surprising if there was an intention to exclude the costs or the obviously foreseeable costs of interpreters in this subset of cases ties in with a point which, out of sequence, I've already made, which is my proposition that it's a false premise to suggest that this can be said to be somehow compensated for by the fixed costs, because the fixed costs are for legal services. They are not intended to, in our submission, to cover services which solicitors need to buy in, and which may often be non-legal in nature, because those are subject to the separate rules for disbursements. Now, the other point that I wanted to make before I come on, obviously, to the meat of this, which is 4529I, is also to note that the fixed cost rules do contain an escape route where the court has a discretion to disapply them if there are exceptional circumstances. But for a reason I'll come to, that is not an answer to the issue of independent interpreters either, because the escape route explicitly provides only for the solicitor's fixed costs and doesn't apply to disbursements. And that's CPR 4529J, which you have in the authority bundle at tab 9, page 151. So that's headed claims for an amount of costs exceeding fixed recoverable costs, and it says if it considers there are exceptional circumstances making it appropriate to do so, the court will consider a claim for an amount of costs excluding disbursements, which is greater than the fixed recoverable costs referred to in Rules 4529B onwards. So in respect of the solicitor's charges, if extra work is required and it can be justified, the court has the discretion to allow more than just to conduct a conventional assessment. But it doesn't have any power to allow disbursements which are outside the scope of 29I, which includes what we've agreed to call by shorthand H. And we would also say that that is an indicator that the court doesn't think that the drafter, doesn't think that an escape route for disbursements is needed, because 4529I is already broad enough to do justice. But in our submission, it's not broad enough to do justice if the way in which it's read in Aldred and Cham is right. So, coming to 4529I itself, which begins on page 149, on the whole, it's not prescriptive as to the amount of disbursements which can be allowed. In subsection 2, there are some specific provisions about the actual figures that you're allowed for in respect of medical evidence in whiplash and soft tissue claims, which we're not here worried about. But in general, in the first part of the rule, what it is concerned to control is only the class of disbursement which is recoverable, and it's pretty prescriptive about that until you get to H. And it's at H we have any other disbursement reasonably incurred due to a particular feature of the dispute. And that's what I think was colloquially referred to in Cham itself as being the catch-all, albeit obviously on the analysis which emerged from Cham and Aldred, it in fact wasn't a catch-all in fact. But we say, again, if one can look at it unconstrained by authority, any other disbursement reasonably incurred due to a particular feature of the dispute. There's no requirement for any sort of technical reading of that. What is the significance of the qualifier? Obviously, the qualifier must mean it must add something. It doesn't say any other disbursement reasonably incurred. It reasonably incurred due to a particular feature of the dispute. But we say the function of that is simply to make it clear that any disbursement has to be specifically justified, having regard to the particular circumstances of the case. And so, for example, you can't just as a matter of...
No, it's not the case, it's the dispute.
Well, that, of course, is the question.
Yeah, but you can't, I mean, don't sidestep it, because...
No, well,
I mean, the point is the dispute in these sort of cases is presumably did A hit B negligently, or did A hit driver B?
Yes.
Was there a particular injury caused by the accident or not?
Well, I mean,
that's the dispute, isn't it?
Well, that's clearly how Lord Justice Coulson sees it. I'll come to how dispute is used in the CPR very, very shortly, because this is the next point. This is the next I'm going to come to. But it is our argument that, in fact, that's part of where Cham goes wrong. It's treating dispute as if it was a narrowly focused word when it's simply synonymous with case or claim or whatever it might be. So I'll try to make that good. I mean, I'm either right or wrong about that, but I'll try to make it good. But also another difficulty that we would respectfully have with Cham is to say, well, even if one reads it in the way that my Lord's just put to me, why isn't a personal characteristic of the claimant a feature of the dispute? And it's a feature of the dispute, for example, that he doesn't speak English, and the rules of court require him, therefore, to prepare an independent translation of his witness statement, and it require him to be accompanied...
But that's a feature of how the dispute is resolved.
Yes.
It could be said.
Well,
not of the dispute.
Yes, so that's, if I can respectfully say so, is piling nicety upon nicety. In circumstances where what we would ask is, if one steps back, and with respect, Lord Justice Coulson doesn't do this, why, I ask rhetorically, why would the rule maker decide to draw a distinction between a feature of the case and a feature of the dispute? I mean, what sort of policy within Section 45 is that nice distinction intended to serve? Because on the face of it, it leads to a conclusion in respect of interpreters which is extremely startling. Namely that although you are a citizen of this country, but you don't speak English, or you're deaf and you need a sign interpreter or something of that sort, you have to pay for it yourself, and you can't recover it from your opponent even if you win, even though you can recover disbursements which do arise out of the dispute. For example, a report on the accident locus from an action reconstruction expert or something like that. My rhetorical question is, well, why? I mean, why would the rule maker draw that distinction? You can well understand the other policy that is analysed in Aldred. The rule makers obviously can't have thought that a party can recover as a disbursement that in respect of which an allowance had already been made within the fixed cost which goes to the lawyers. So
that's issue 2 of
that's issue 2. So that's with respect, that's a very easy point to understand. But what there is, I would say, no analysis or reflection on in Aldred is if this distinction is right and dispute is to be given this more focused meaning. Is, well, I mean, why would the rule makers say that you can't get something which is a characteristic of the claimant, or it might be a witness. I mean, this is something which could just occur completely by happenstance. That you have an accident in an area with a very high, you happen to be driving through Southall, say, on your way from Heathrow Airport back into town, and you have an accident, and all the people that witness it are people that only speak Punjabi.
Can I? That leads me to a point which has been giving me a bit of trouble. H says any other disbursement reasonably incurred due to a particular feature of the dispute. If you look at the list above, A to E, one can easily see fit with the Cham approach. But F and G are specifically referable to characteristics of individuals. Because
they are.
Now, why? Am I right in thinking there's no reference to this in Cham, but on normal principles of construction, where you get something built like that, doesn't that carry the implication that F and G are, for the purposes of this rule, disbursements reasonably incurred due to a particular feature of the dispute?
Well, indeed, I would certainly say that is.
Well, the only thing that gives me cause for hesitation is the fact you haven't raised it as an argument in your skeleton.
Well, it is fair to say that we haven't raised that point in our skeleton, which is a relatively short document, as you've seen. But it certainly is a point that I raise now.
Well, I think I've raised it now.
Well, I gratefully adopt.
Well, my lord, my lady may think it's a rubbish point.
They might.
So don't just adopt it for the fun.
No. I mean, what I would say is that this is a sequence of provisions which as it were have H as the apex of the pyramid, and it follows sequentially on from what goes before, which is, and the signpost of that is any other disbursement, as my lord has just said.
Can I just read before we leave? I don't know if you're going to leave this now, but it struck me anyway that the Coulson distinction between a characteristic or a disbursement related to the individual as opposed to the dispute doesn't really work when you get to medical reports, because medical reports might well be about the whiplash injury or something that happened in the crash, but they're quite often also about pre-existing problems and how that's interrelated with the particular accident. And those are very specific to the individual concerned.
Yes, I mean, and then could there be a nice issue as to whether or not, well, if it actually goes to something which is part of the dispute as what the quantum of damages be, it's the right side of the line. But if it doesn't, it's the wrong side of the line. I mean, what one also has, and I was thinking when I gave my example just now of a Punjabi witness, on Lord Justice Coulson's analysis, if the witness who has seen the accident only speaks Punjabi, is that a feature of the dispute? It's clearly not a feature of the claimant. So do you actually get the translator for the witness? But if the claimant also only speaks Punjabi, you don't get the translator for the claimant. So it is. These are very nice distinctions. Which
yes, and if the claimant's going to give evidence, do you get the interpreter while he gives us evidence, because that's to do with the dispute, but not while they're sitting outside talking about it?
Well, even though what they're talking about is probably giving instructions in respect of the dispute.
But that's the essential. That's the essential purpose of an interpreter.
Indeed. Well, exactly. They're not there for. I mean, they're there because of. And I appreciate my Lord Justice Snowden has put to me. Well, that's all about the dispute resolution rather than the characteristics of the actual list, as it were, between the claimant and the defendant. And that's where I said I hope not.
It's not one of the matters in issue in the dispute.
Right. And again, I asked rhetorically, can it possibly be thought that these very nice distinctions were intended? Particularly when if they are, it leads to a result which, in my respectful submission, it just seems to be completely aberrant. Even before one gets to the new rules about witnesses with vulnerabilities or fragilities, to suggest that uniquely in this subset of personal injury fast-track cases, you can't recover a disbursement which you can recover everywhere else. And where we would say it's absolutely fundamental to access to justice that you can understand the language the proceedings are being conducted in. I mean, why? Forgive me if it's seen as too energetic language, but why on earth would that be the outcome which the rulemaker had intended? And with great respect to Lord Justice Coulson, and in fairness, because he's not examining interpreters, he doesn't analyse or explore these questions. And whether that assists me at this level, I appreciate, is another question.
Well, could it be a point of distinction?
Well,
could it be a point of distinction that council's opinion on the settlement sum is not an articulation of the dispute, or is not a question of access to justice, apart from the fact if you don't have counsel's opinion, you don't get a settlement order from the court.
Now, I've obviously pondered long and hard on that question myself. It does take us back to what I already suggested is quite an unusual situation here, because what we have is not so much, it's not a direct ratio, but what you're saying, it is the reasoning from which the ratio, you can't get the barrister's fee, is directly extrapolated, is a reason which appears to apply, mutatis mutandis to the fees of an interpreter, because the need for an interpreter arises from a characteristic of the claimant rather than the characteristics of the dispute, as the Lord Justice understood that term. But I mean, certainly one can, and so really what we have here is the facts of this case enable arguments to emerge, which one can understand why they didn't emerge in the rather drier context of can you get counsel's fee for an opinion. But whether they're points of distinction, obviously, I would submit that they are, but I have to assume it's very fine.
That may be a point of distinction. That counsel's fee does not go to access to justice, and therefore is not susceptible to the arguments which you advance based on the overriding objective.
And even on the overriding objective as it stood in at the time of Cham and Aldred, there was the requirement to ensure the parties are on an equal footing. I would venture to suggest that it's almost impossible to believe that if the case had actually involved an interpreter, the Lord Justice Coulson wouldn't have focused a great deal of attention upon, well, what does that drive me to conclude?
I mean, he thought he was very specific that he could make his decision by diving into 4929L. He wasn't going to bother with the overriding objective or anything else.
No, and I have to say, with obviously, I've not had the privilege of being in front of Lord Justice Coulson many times, and it's discomforting to be, subjecting a judgment of his to such sceptical analysis, if I can put it that way. But again, an extraordinary omission in my respectful submission is he doesn't cite, not only does he not refer to the overriding objective, he doesn't refer to the immediate following provision of the overriding objective, CPR 1.2, then interpreting any rule, the court must apply the overriding objective. Now again, that can perhaps be explained because considerations like equal footing and fairness are rather less prominent in the context of the particular fee with which he was concerned. But in my respectful submission, when it comes to the interpreter, without whom you can't participate in the proceedings, it's almost impossible to think of how they could be more directly engaged.
So, I mean, and just at some point, I think you flagged that you were going to deal with a more sort of nerdy point about actually looking at the use of the expression claim and dispute.
Yes, I'm going to do that next, I think, actually.
Okay, I'll hold fire.
Obviously, I'm in your hands if you want to fire something at me now. But...
No, it relates to that. So
right. Well, let me move on to that. Just
your submissions so far are no policy reason for restricted view. This is fundamental to access to justice. Counsel's fee. You've taken my suggestion on any other disbursement, and counsel's fee is not a feature of access to justice in the same way as an interpreter.
Yes. The other point I would make about, and I'm not suggesting this takes us very far, but insofar as perhaps there might have been a sort of thinking in Aldred, well, the whole nature of these fixed cost regimes, and I think the Lord Justice does say this somewhere, is there's a natural forensic, there's a natural and understandable forensic impetus on claimants always to be sort of pushing to enlarge when clearly the sort of underlying purpose on the rules is generally to constrict cost recovery than to allow it. But I would also say, again, it's the provisions which my Lord Justice Stuart-Smith put to me. I mean, those provisions show that actually, in some respects, this area isn't constricting disbursements. Because, for example, being able to, the provision in G that you can get the party's loss of earnings for attending court. And that is not a disbursement, which in fact would generally be regarded as recoverable. That's something which creates a right to recovery, which certainly, as I understand, the authorities relating to detailed assessment doesn't generally exist. And clearly, in our respectful submission, it is going to matters which have got nothing to do with the dispute in the narrow way which the Lord Justice interpreted it. On any view, they must be going to matters relevant to the determination of the dispute, the need for the claimant and the witnesses to attend at court. And I do also say that here too, it appears to be, with great respect, an irrational policy that you can get your costs of your train fare for going to court, your foregone earnings for spending the day at court, but you can't recover the fee, and all of that is a feature of the dispute. But you can't recover the fee of the interpreter that you actually need to participate. So I will, if I may, then just deal briefly with the other uses of dispute.
And your point, just I think it was said, but one of your distinctions is that the council's fee in the particular case was to do with settlement, not resolution, not the dispute as a court exercise, other than the fact it's to do with settlement.
Yes. I mean, look,
you don't need the opinion. You don't need counsels.
Yes, you do, because you can't settle a case for a protected
You need it for
party
settlement.
unless you've got.
Yes, but that's the point. It's you only need it. You wouldn't need it if you ran the case to trial and there was a determination. You only need it if there's a settlement.
You don't need it for the resolution of the dispute itself. It is simply to enable the settlement to be carried into effect. And what I think, strictly speaking, obviously the point that's just been made by my lady is correct in the real world. But I mean, I think the strict analysis is without counsel's opinion and the judge's approval, the settlement isn't binding.
Yeah, no, I'm completely with my lady. When she's
yes.
I think the distinction which you drew a little while ago in your submissions was one of the other points of distinction, which might separate Cham from this case. You say is you can't participate in the dispute resolution process without an interpreter.
Yes.
But you can participate, even if you're a child, in the dispute resolution process without a counsel's opinion.
Yes.
The only point in time at which the counsel's opinion is needed is when the dispute resolution process is actually being settled.
Yes.
Which is actually not actually part of the dispute resolution
process
per se.
The dispute has been resolved subject to that legal formality.
I mean, it's a very very fine distinction, but you say you can understand why somebody would say, well, it's not a feature of the dispute in any sense, because it's actually just a necessary condition for a settlement out of court.
Yes.
Or, basically.
Because and one of the things that's often forgotten actually about infant settlements is they're not just there to protect the infant; they're there to protect the defendant. Because without a court order, without a translation of the settlement into a court order, the infant, of course, he or she can't contract. So there's always a risk that an infant could actually disown a settlement when they reach their majority.
Yeah.
It carries the settlement into legal effect. That's the function. That's the function of.
I have to say, at least at the moment, and I certainly haven't formed any firm view, but when you come to look linguistically at the use of the words claim and dispute, one provision you might actually look at is just a couple of pages earlier in the bundle, which is where claim is and dispute are used in this very regime.
Yes. Well, shall I come on to my...
Which is not one of the ones I think you rely upon,
no.
but which actually gives you a sort of clue that the dispute might be used rather more narrowly than claim. It's not one you deal with, so I'd quite like you to deal with it.
Yes, well, it's long held it. Let me try to come to it. So the word I'm just looking here at the costs sections of the CPR. Obviously, I can't prove a negative. But we've looked at them quite closely and we've conducted word searches and such like. The word the reference to a dispute first comes into the cost sections of the CPR when costs-only proceedings are created. So let me just go to the right page of my notes. And that's with what was CPR 4412A, and you have that in the bundle, the authority bundle, tab 10, page 167.
So that came in 1998, did it?
It actually comes in, my lady, you'll see at the top of the, just under the superseded, it actually comes in the 3rd of July of 2000. So costs only, and that's why it's 12A rather than part of the sequential numbering of the CPR. So costs only proceedings come in slightly in arrears of the CPR themselves. They're an innovation that come in about a year after its nativity, as it were.
I'm so sorry, I haven't followed that through. Can you just help me? I'm in tab 10.
Tab 10, page 167. I hope.
Yeah. Yeah.
That should be 4412A.
Yes.
So you'll see at the top of under the heading, it says version 1, 3rd of July 2000.
I was on the right page.
Date. So it comes in very early, but not right at the 26th of April 99. And it sets out a procedure which may be followed where the parties to a dispute have reached an agreement on all issues, including which party is to pay costs, which is made or confirmed in writing, but they haven't agreed the amount. So that's where the first reference that we have been able to find to a dispute comes in, and we say that.
Sorry, why aren't you just looking at the? Why can't we look at the use of the expression dispute and claim in the fixed cost regime we're looking at?
Well, we're going to. I mean, I'm just starting here because this is the first time that this is where the word makes it. I mean, this is where it bursts onto an expectant stage in 2000, where the term a dispute is introduced into the CPR for the first time. And it's referring to, we would say it's just referring to a case which is settled without issue, without proceedings being issued. But because ex hypothesi costs-only proceedings are cases where it hasn't been necessary to issue proceedings. And the word dispute is being used even though, again, ex hypothesi. It's a case where there won't have been a very significant dispute because it's settled without one even needing to issue a claim form. So that's where it comes. Then, my lord, you're quite right to chivvy me on. I should perhaps say, just for completeness, 4412A still appears in the rules, but it's now 4614, and you have that in the same division of the bundle at page 165, so 2 pages previously. But it's essentially the same, and it still refers to the parties to a dispute who've settled it, where they've agreed everything without issuing proceedings apart from costs. Then one comes, as my lord has been putting to me, to its appearance in part 45, which is in tab 9. The first reference, in fact, before I come to the provisions which my lord has been putting to me, is in section 2 of part 45, and you've got that at page 127. So this is another fixed recoverable cost scheme relating to road accidents. It's mostly now superseded by that which has come after. So at one time this was this would have been a sort of very mainstream provision in the county court, but it's sort of in runoff, if I can put it that way. But what sort of case does it apply to? Well, again, it applies to cases which have settled without the need for proceedings. So you'll see at 45.9, subject to paragraph 3, the section sets out the cost to be allowed in proceedings to which 46.14.1 applies costs only proceedings, or proceedings for the approval of a settlement or a compromise. So this applies to cases which have again settled without proceedings having been necessary apart from proceedings for approval, and it applies, and this is subsection 2.
So that's a child or other person under a disability.
I'm so sorry. Yes, that's right.
B is a child or someone else under a disability.
Somebody else, like a person with a psychiatric condition, for example. Yes. And then the section applies. This is 2A, where the dispute arises from a road traffic accident. So again, that is just dispute, as we see it, being used really synonymous with a case. It's and a case where, by definition, there hasn't been any sort of issued dispute, because it only applies to cases which haven't been issued or been issued only for the purposes of approval. So dispute there is not in any sense in our submission being used as a technical term to refer to there being a sort of extant list between the parties about which they are arguing at the point at which the relevant costs have been incurred. It's simply referring to a claim. We do surmise, and I do accept this is just surmise, that perhaps the word has been alighted upon, because in general, under the CPR, a claim is something where proceedings have been started. But I can't point to anything which makes that good. It just is what appears to us to be a rational explanation for this new term having been alighted upon. And then the word dispute then appears at various other junctures in Part 45. I think its next occurrence is at page 129. And this is still section 2, and section 2 it contains its own catch-all, which is very similar to the H catch-all. So you've got that at the foot of. It's the last provision in 45.12. This allows disbursements, any other disbursement that has arisen due to a particular feature of the dispute. And that's a terminology. That terminology is used in this same section 2, where, as I sought to show at the beginning, the term dispute, it simply appears to be performing the function as a synonym for case. And certainly, since these are proceedings which by definition, otherwise they wouldn't be in section 2, have settled without controversy or proceedings even being necessary, there really won't have been much of a dispute in the more aggressive sense, as it were, of that term. And then the term is used in section 3 of CPR 45, which, if we go forward to page 133, that's the other catch-all. The catch-all for the section 3, any other disbursement that has arisen due to a particular feature of the dispute. Hold on.
Where do we find that?
This is the foot of 4519. Rule sub rule 2 little e, and that is it's about halfway down page 133.
That's H's version.
That's
section 3's version of
that's
H.
section 3's version of H. I'm not making a submission about this. I'm just showing to you for completeness. And then further down, you see it again in section 3 at page 140. There's still section 3. In 4529, this is another rule that goes to costs-only proceedings. 4529, this rule sets out a procedure where the parties to a dispute have reached an agreement on all issues, including which party is to pay the costs, which is made or confirmed in writing, but they fail to agree the amount of those costs. So this is really the analogue to the rule, which the 04412A, which we were looking at earlier, which is specific to the section 3 provision, and it essentially replicates it. And again, in my submission, there's nothing to indicate there that dispute is being used as any sort of term of art. It's just in our submission synonymous with a case or a claim. And then we come to section 3A itself, which is obviously the section which my Lord has put to me.
So, in my bundle, we start at 140, yeah?
Yes.
And is this right? There is, in fact, a title which I can't read in my printed copy, but it is section 3A. So this is a new section 3A, and I think it says something like claims which
no longer continue under the RTA or ELPL pre-action protocols.
So
I can't see it on screen either.
It is there, but it's so faint.
No, we can. We'll try to do something to assist with that.
I mean, it is actually. I can see it electronically on screen as well as in the print.
Justice Staunton would go bonkers.
Yeah, he wouldn't be using it.
Well, obviously, I don't know if the overriding. I don't know if the overriding objective has any, even as amended, has any protection for the eyesight of learned judges. But probably we can deal with that in the next update.
Right. So you have a new section 3. This is a section 3A which is brought in as a piece.
As a piece, yes.
So I think my sort of first point to you is that when you're looking for linguistic clues as to what the word might mean in this section, you primarily would look to the piece in which it all appears. You know, it comes in as a as a whole. I mean, that's your first port of call, rather than all the rest of the stuff. I mean, the draftsman of this piece, which came in as a whole, would be presumed to have
used it consistently.
Well, you know, what the draftsman would have meant is probably primarily to be, at least the first port of call, is within this regime, which is brought in as part of the whole.
Well, I did. Your Lordship may remember that that's actually a point of controversy in Cham and Aldred itself, where Lord Justice Coulson only wants to look in an extremely localised way at what Section 3A provides, and actually criticises counsel for iterating their way through the entire part. And then Lord Justice McComb says, "Oh no, actually, I found that jolly helpful." And Lady Justice Nicola Davis agrees with Lord Justice McComb and says you do have to look at matters as a whole. But I certainly accept. But no, but I don't think your Lordship is putting it to me as highly as Lord Justice Coulson put it, that it's just irrelevant.
No.
So as your Lordship puts it, with respect, I don't disagree. But obviously, I do respectfully remind your Lordship what the majority said in Cham and Aldred. You also do have to look at it holistically.
You are hoping that the draftsman of this particular section, Section 3A, might have actually looked throughout the rest of the rules to figure out how the rest of the rules use particular words or phrases so that the rules are coherent.
Yes.
But at least as a first port of call, you look within the actual change that's made to see how the draftsman of that change was using the...
I certainly wouldn't disagree that must be your first point of call. However, I would perhaps... what your Lordship has perhaps put to me is a slightly... as the pious hope that the draftsman would have been consistent. But I would put it rather more strongly than that and say there would be a pretty strong expectation that the draftsman has used an existing term consistently unless there are contraindicators to that. So it may just be a difference of emphasis, my Lord, between what you put to me and how I respond to it.
This is not a complaint, but in fact, the layout, particularly of the tables, is much easier to read if you look at it in the white book.
In the white book, yes.
Than on this version.
So what we will do is we'll get part 45, the part 45 section in the white book printed out and scanned as well. I've got a PDF of it already, so we can certainly have that emailed to the court more or less straight away, and we can get hard copies sorted out over the short adjournment.
Well, the court's got access to a white book.
Oh, of course, yeah. Very good. Well, in that case, I'll assume that...
I wouldn't bother. I mean,
I'm grateful.
My lord, my lady may not agree with me, but I'm just saying I find it much easier to follow this in the white book than in the version that's been put in the authorities.
Thank you. Yeah. So now I assume that my Lord Justice Sneddon was about to put something to me, so I'll...
Well, I'm just going to wait to see whether you're going... I mean, I think we both know the provision that I'm about to put to you if you don't deal with it, so... I mean, maybe you don't.
Well...
I'm just intrigued.
Well, I foresaw that you might be planning to put to me 4629I at 2, which uses the terminology of a claim started under the RTA protocol.
No, I was going to put to you 4529F 4. The value of the claim is the amount
not
specified in the claim form, excluding any amount not in dispute. I mean, that seems to me to make a very clear distinction between a dispute, what is in dispute, and the amount claimed more generally.
Well, and that's...
which focuses on, the real, as it were, issue for the purpose of the proceedings, which is, to be fair to Lord Justice Coulson, what he, I think, linguistically appears to have focused on, which is what's actually between the parties in the proceedings, the issue.
Yeah. Well, I wondered if that's what you were going to put to me. I mean, my approach to that is directed at a different question. This is a question which arises throughout the CPR. I mean, for example, if you look at Part 26, which deals with allocation, that also directs you to disregard anything which is not in dispute. And so, if you've got your £100,000 claim, it can still go to the small claims track if actually only £500 of it is disputed. So it's a proper concept. So this is yes, this is saying that for a certain purpose, you value the claim for case management purposes by looking at what is actually in contention. But in my respectful submission, that's a rather different function than the way in which the term dispute is being used in these other passages which I've been showing you, which in my submission include H, where dispute is just being used synonymous with a case.
No, I understand
So that's the distinction I draw for good or for real. That's my answer.
But at least that use of the use of the expression dispute, I appreciate it's in dispute rather than the dispute, is at least supportive of Lord Justice Coulson's narrower reading, if I can put it that way.
Certainly, in the question which that is focusing on is a focus as to yes, what is actually in contention,
and that is where Lord Justice Coulson essentially came out, isn't it?
Yes, indeed.
He's saying,
yes,
what is in contention doesn't actually include something which you need to produce in order to persuade the court to validate a settlement.
Yes.
Yes.
I mean, my argument is simply that your Lordship is quite right. I'm not trying to duck your Lordship's question. The way dispute is being used in this context is sort of focused upon the issues that Lord Justice Coulson focused on, but I'm saying the context is really quite different.
Although, just to be clear, I mean, in one way that you put your argument, this supports you.
Yes. Because
it emphasises the point Lord Justice Coulson might have been focusing on, which is that the council's opinion wasn't necessary to resolve
the dispute,
as opposed to being as it were, a feature of the issue between the parties, if you define it that way. The broader way you put your argument, I don't think is supported by this, which is you just say, oh, it's anything to do with the features of those involved in the claim.
The argument that dispute in some contexts is just a synonym for case, and may be used, for example, because claim or case in the CPR typically, or at least can mean something which has been issued. It's not consistent with that. But my explanation to that is simply the contextual one. Yeah. And I appreciate that one always does feel that one is slightly, on the proverbial bridge of thin ice if one is relying on the presence or absence of the definite article. But in this instance, I would say when you're talking about the dispute rather than what's in dispute, there's really, in my submission, are addressing separate things.
Or are capable of.
Or are capable of, and should be construed as being in this context. So that's, I mean, it's against that background that I mean, perhaps this is the point at which we should come to Cham. I think the key passages are at page 332 of the authority bundle, or they begin there. Oh, Mr. Brown's reminded me about taking a short break. I wonder if you'd like to
press on a little bit. Just press on for another quarter
an hour. Yes. Please, thank you to Mr. Brown for that. If I forget again, obviously I will be reminded. So yes, so the discussion in Aldred, it's the.
It's really paragraph 35.
It is.
With a bit of explanation in 36.
Yes, so he introduces it at 32, at 33 and 34 he considers two first instance cases, one of Judge Wood and one of Master Campbell. And he obviously appreciate, again, without impertinence, my submission is that he actually approves the wrong one. Obviously, that follows inexorably from my submission that I have to say that. Then, as my Lord has just said, at 35 and 36 is really the key of it. Someone who cannot speak English or who requires an intermediary is nothing whatsoever to do with the dispute itself. Age, linguistic ability, and mental well-being are all characteristics of the claimant. Regardless of the dispute, they are not generated or linked in any way to the dispute itself, and therefore cannot be said to be a particular feature of it. and then he identifies what are the particular features, and they're not dissimilar to some of those that my Lord Justice Snowden put to me a few moments ago, and really that is it. And then at 37, the cost of counsel's advice in the present case was not necessitated by any feature of the dispute, but was instead required because it's an almost mandatory requirement in all RTE cases where the claimant is a child.
I mean, he's wrong. He's wrong about that, isn't he?
Well, it's obviously not required in all art. It's required as my lady said, it's required for a settlement to be approved.
It's not required if you go to trial and the court resolves.
It's just not required to have access to justice.
No.
If you are a child, to bring an RTE case. I mean, that's if we are looking for a point of either distinction or if either he's incorrect or we're looking for a point of distinction, I mean, that sentence taken as baldly as it is stated is not actually correct. In a sense, it's not a matter, as I understand it, and I'm happy to be corrected, but I think my lady put it correctly. It's not actually a requirement to bring an RTA case.
No, you certainly don't need it
if you're a child.
He's right to say it's a mandatory requirement in all RTA cases where the claimant is a child if you want to conclude that case by settlement.
Settlement, correct.
So he's not
That's
wrong,
it.
but he's not making the distinction my lord makes.
Yes, which yeah, I think that's right. And that would.
Yeah, so Mr. Eastwood reminds me that this may be as much for you, the court's note, as anything I'd ask you to sort of get out white books and turn up. But 2110 in the white book, which deals with approvals, at 2110, I think it's 3H, you're asked to file a legal opinion on the merits of settlement, except in very clear cases, together with any relevant instructions unless they're sufficiently set out in the opinion.
You cited that in your
We have. So, I mean, you don't actually always need one, and there's certainly nothing in that rule which says it has to be from an independent member of the bar.
But practically, yeah, okay. But the point being is, if we're looking at this in terms of, as you I think urge us to do, in terms of access to justice and equality of arms and the overriding objective, it's not right to say you need a counsel's opinion to engage in the dispute in all that ways.
No.
It is. If you want to settle, it is mandatory in many
Indeed,
cases.
And also, I mean, it must be said that in quite a lot of small cases, I mean, it isn't always done. There's some defended insurers are happy with essentially what's I think referred to as a parental undertaking, where the parents undertakes that they will indemnify the defendant in the extremely unlikely event that the child subsequently disavows the settlement. So this isn't something that exists in the rules, but it is something which, as I understand it, exists in the market, but probably for the sort of case which is settled for
I'm just
£500.
raising an eyebrow because it's outside my experience.
Yes.
But if you say so.
Well, I mean, that's my understanding. Will you forgive me for a moment? Mr. East was very anxious to communicate something to me.
No,
But you might well just get the solicitor.
Yeah, I know.
I thought I understood how these things work.
Yeah.
Yeah, you'd almost certainly.
Yeah. Okay.
If there's any
really see how that helps us.
involved, you'd have to
I mean,
get some sort of counsel's opinion.
Or the solicitor could do it. You often find some solicitors are very skilled. They might work. So you don't have to get independent.
But you accept that that used to be.
Because your protection is one, the opinion, and two, the court looks at it and approves it. Yeah.
Just on that last one about parental indemnities, which of course your lordship to raise an eyebrow, I took that advantage of that to have a quick discussion with Mr. Dean, behind my learned friend, who knows as much about the motor insurers and their practices as anyone, and he confirms that that was at one time a relatively well-known practice. He says it's much less common now, but so and I'm not suggesting anything turns on his end.
No. And of course I accept what you say. It's just I hadn't come across it, and I thought I was aware of most aspects of practice.
Well, there's quite a good book on motor insurance, as I recall.
Don't remind me. The second edition is very good.
They're still on Amazon. They're still on Amazon.
Not quite. Not quite a bestseller anyway.
Well, maybe after the short adjournment, my lord, I'll bring my copy and ask for it to be autographed. Or perhaps not. I mean, that's what Cham says. Respectful. Obviously, I appreciate that it may be beating the air to make a respectful critique of it, unless I can show either the caravan's moved on or it's per incuriam. But what we obviously, in addition to the points I've already made, specifically,
well, or just, I mean, yeah, where we have been is actually neither of those two.
No.
It's your other way of putting this, which is that actually there is a material distinction
Indeed.
as a point of principle between the interpreter and the ratio of this case.
Yes. But that's so. Yes, I mean, clearly, what I was about to come to is what I would say about it if I can't distinguish it, either for the purposes of trying to set up an argument that it is flawed in a way that the doctrine of precedent allows the court to depart from it, or which is also not irrelevant. It might be relevant as to whether or not this would be a case where this court would say, well, we can't escape from this, but because, for example, we are concerned about its Human Rights Act implications, this is a case where the Court of Appeal has a duty to grant permission to appeal as part of this court's, as permission to appeal to the Supreme Court, as part of this court's own obligations under the Human Rights Act as a public body, to act in a way which is consistently with it. And one of the things you may remember in the early years of the Human Rights Act, there was some debate about whether or not it created a new exception to stare decisis, and courts could depart from the doctrine of precedent if older cases were thought to be inconsistent with the rights which the 1998 Act entrenched. And the answer of the House of Lords was no, the doctrine of precedent still applies. And the way that lower courts will discharge their obligations is to grant permission to appeal if they think the precedent needs to be revisited. So I say that partly just so you know why I'm not just wasting my time in a sort of, and wasting your lordship and your ladyship's time in an impeachment of Cham and Aldred. It does actually have a forensically relevant purpose, both as to whether or not there is scope for this court to depart from it, or if there isn't, whether or not in due course this court should grant leave to appeal to the Supreme Court, right. so that it can be considered by a court untrammeled by authority.
So you're moving on to that now.
I am, but right. I think my
Let's take
was.
Should we take 5 minutes?
Can I just have one sentence before we go, and then we'll go on 5 minutes? Does it follow from what we've covered this morning that the option which might appeal to some courts in some instances of referring it back to the Civil Procedure Rules Committee is a non-starter here, because they've already looked at it and they've told us what they're going to do in October. So that doesn't carry anything. So the issue for us is what we do now, and if we think we're bound by Aldred, then we have to start thinking about things like permission to appeal.
Yes, I think so, because the Civil Procedure Rule Committee clearly have looked at it, and they've made a change which
it's prospective only,
which is prospective.
This is all on the assumption that we accept your argument that Aldred is effectively wrong.
Of course, and as I think I said right at the beginning, I mean, I appreciate not being presumptuous about that. I mean, that's taken as my premise, and if you reject that premise, then obviously there it is.
End of. Okay.
Right.
5 minutes. What's the time now? Just gone 25 to. We'll come in just after 22.
Very good, my lord. Thank you.
All right.
In the case of Aldred, and that can be one of the bases on which the distinguish prayer and curing. That's the relevant section of Bristol, on which they don't have regard.
I mean, it's the provision is not present to its mind. That would be the Human Rights Act.
So there's no question that human rights considerations were not.
It was very good, actually. Yeah.
Yeah, no question.
I was going to come down last night.
The reason for that is that there was no question of access to justice
Yeah.
considerations
Because it was, yeah.
advice is not strictly necessary. The cost is provided for elsewhere. And finally, of course, when it comes to children, as Aldred was,
So you
they
try and
will
find that
always
today.
retain a majority. And therefore, you're guaranteed that they have access to justice between the ages of 18 and 21.
Yeah.
And even if there's a settlement, what you could do is
Oh,
just
right.
stay with proceedings pending majority. When the child reaches 18, they say, yeah, I'll take that, or no, I want to go on and fight. So that is why we can distinguish Aldred and say that the ratio is per incurium insofar as there were no human rights considerations.
But I mean, in fact, you don't actually even need to say per incurium, do you? Just as the point just didn't arise.
Yeah, it didn't arise, but even if they consider bound by the reasoning, then it is pure per incurium.
Because it's a statutory.
Because it's a relevant statutory,
This is the last
you
thing I
know,
wanted to
an
do.
important statutory instrument to which they had no regard. And therefore the court should reconsider the matter of the benefit of their Section 3 human rights obligations. And that's perfectly permissible. And the other thing about the referral to the Rules Committee, of course, the Rules Committee can't act retrospectively. Number of appeals have been stayed pending the outcome of this.
Oh, really?
And the rules changing in October are only for cases issued after October. There will be several years of cases.
Yeah, that's a good point.
ongoing.
That's right, is it? We've got the transitional provision that says that.
I've seen the. We're going to check with ours.
Right.
Sorry, just to check the new rules. Those are for cases issued after the 1st of October, aren't they? They're not retrospective.
Not retrospective.
Yeah, I had seen that. I haven't seen the transitional provision in the supplemental bundle, but I'm sure if necessary.
Yeah.
Normally, of course, the transitional provision is with the instrument, and we aren't there yet. So they haven't announced the they've announced that's the intention, as is the norm. But we won't be able to refer to a
Yeah.
instrument because it won't
Yeah.
be
It's okay if you can't go. It's okay. You sure? Thanks very much. All right.
Sorry for the overly.
They're all going to pay very well for these jobs.
Oh yes, the other thing about the intervention about dispute, of course, the location of the accident may not be disputed. It might not be a disagreement,
Yeah, you got disbursement.
but it still may be a recoverable disbursement insofar as it arises to a locus report. And indeed, in the directions as is the norm,
But it's relevant to liability, isn't it? You need to like see what the scheme looks like to like determine who's to blame.
but it's a feature of the dispute insofar as it doesn't require disagreement in the same way that a characteristic of the claimant is a feature.
Oh yeah, I agree with that, but I'm not really sure that's the point we face, is it? I mean, the distinct. I mean, he doesn't. Coulson doesn't say something actually has to be actively subject to dispute. That's not the distinction.
No, but where he refers to the question of it being in dispute, he says that that's analogous. Of course, that analogy breaks down when you see that
Yeah, I
the
see that.
features of the dispute don't require disagreement.
I do see that. Yeah.
Still recording, by the way.
Of course, these are just. It's 5B of the directions, or is effectively the parties must use it for locus. That often arises. Sorry, leads to a locus report.
Yeah. Yeah. Of course it does. Yeah. Thank you.
working on that chronology now as well.
Okay. Well, I mean, they clearly have that this evening, so I wouldn't make that your priority.
Yeah, of course.
Cool, right?
Yes, Mr. President.
Yes.
I'm conscious that we've interrupted you a lot and slowed you down a lot, but you just need to keep a little eye
I
on
do.
the time.
You're quite right. I was thinking the same. I agree. I think it's one of those things where it's been, and this is my fault, of course. Insofar as it's been a little bit formless, I do hope that it's actually will
No, I think we've come
quite
to,
briskly.
we know where we are.
I'm obliged.
And your skeleton is completely clear.
I'm grateful.
So don't feel you have to, as it were, read it all out again.
No. Well, I hope that isn't my I hope that isn't my usual style
Okay.
of advocacy, but I do my best not to go down that
On we go.
that path. Just before I move on, just to sweep up a few points from this morning. We don't have, just in terms of the extent to which this is self-contained, Mr. Eastwood reminds me that lots of other cases have been self-contained because of the forthcoming reform. Mr. Eastwood reminds me that lots of other cases have been stayed because of this one, or at least the recovery of the disbursement has been stayed. And I don't think we've got the transitional provision yet for what's coming in on the 1st of October. But I think the expectation is it won't apply to cases issued before the 1st of October. So we potentially do have several years of cases, even going forwards, that will still apply to that will still be where this regime will still control. And so far as the point about access to justice and the council's advice are concerned, Mr. Eastwood also reminds me that there's not an access to justice element there. Firstly, for the reasons we've already debated, but also secondly, of course, because ultimately the only thing which doesn't crystallise is the settlement, and the settlement will crystallise on the claimant's majority. So if all else fails, you can just wait. And obviously, for lots of claimants who are in their teens, that probably is what happens. It's only for the very young ones that the waiting perhaps does become a bit of a theoretical exercise. So far as
unless they repudiate it.
Unless they repudiate it, yes. But then if they've repudiated it, then I mean, far from not having had access to justice, their access to justice then in years, and they no longer need the advice. So far as the Cham and Aldred is concerned, we obviously will have to show you Young and Bristol Aeroplane just as a reminder of the categories in which this court can depart from stare decisis. But the real thrust of our argument, particularly insofar as we rely on the 1998 Act, is the 1998 Act simply didn't really apply in that case. And there wouldn't have been questions about access to justice or discrimination on the basis of language or nationality or disability in the case of somebody who needs a signer, because obviously none of that arises on the facts about an infant approval advice. And because of that, we say the Lord Justice did not have in his mind controlling provisions which would have dictated a different outcome had they been put in his mind. And we say that that does enable this court to say it's a per incuriam decision in circumstances where the court does have that advantage. And we'll put up Young and Bristol Aeroplane and identify the passage where we say it is open to the court to depart from this case without more. And insofar as we rely on provisions that were not cited, you already have my points about the equal footing obligation of the overriding objective. That's not mentioned. As it even then stood, and you have my point about CPR 1.2 and the court's positive obligation when interpreting any rule to have that provision, to have the overriding objective in mind. And I would also say, of course, we mustn't read judgments as a statute. And of course, in many scenarios, one would say a judge's experience, and if I can respectfully say so, as fair as Lord Justice Coulson, one would say, but he must have had the overriding objective in mind. And one could sort of sweep it away, sweep an impertinent critique away in that way. But in my submission, you can't say that here precisely because of the different subject matter which we have here, which engages considerations that simply were not before the Lord Justice. And although he clearly thought about interpreters, there's no indication whatsoever that was subject to any sort of debate. And as I say, things that surely, for even the most inexperienced advocates, some really very obvious points would have emerged if it actually been subject to, had that been subject to the debate, the ones I've already mentioned, and the 1998 Act, which obviously gives us a positive right, access to justice, which the Strasbourg jurisprudence tells us must be effective, and forbids discrimination on basis of nationality. We accept, of course, because of Brexit, European law doesn't apply to the decision of this court, but we also do make the point in our skeleton that actually, for most of the life of CPR 4529, well, let me just call it H, most of the life of H, this country was a member of the European Union, where discriminating by language or nationality against the citizens of fellow EU member states would have been a starker departure from the EU Charter of Fundamental Rights as it's really possible to imagine. And again, in our submission, that it must be assumed that when H was enacted, that there couldn't have been any intention to discriminate on the basis of nationality or language. And as to is it discriminatory, my learned friend argues that it isn't, because you can always go along and get your solicitor to act as a translator. I think I've already really preempted as why we say no, that's not a good answer, because it just... Okay, well, good. I'm glad it's not your case. I'll stop misstating your case and wait for you to state it. So, but in any event, there's not a lacuna that can be filled by the solicitors thus dealing with matters on an ad hoc basis. So that's what we would say if the caravan hasn't moved on, that fundamental points were not before the court. I obviously also do make my point about dispute just being used as a synonym of case, and dispute in this context not being the same as in dispute, because the characteristics of a dispute, which the Lord Justice himself recites at paragraph 36, it's not part of his recitation that those things actually have to be in dispute. So he includes in that the circumstances of the accident, for example. The circumstances of the accident will very commonly not be in dispute.
No, but he's giving examples of things which, would be in dispute. Which would be in dispute if they weren't agreed.
Yes.
For the purpose of this, who hit who.
Well, that's only true, but that my submissions.
But obviously, in a particular case, it may not be in dispute who hit who, but it may be how fast were they travelling.
Yes.
But
or yeah, I see that, of course. So far as so I think that really does just leave the submission as to whether or not the caravan, as I've been putting it, has moved on. Now, what we have here is as by way of background, is as you will know, Cham and Aldred. One wouldn't usually suggest a refusal of permission to appeal has a great deal of significance, and I don't suggest it has vast significance here. But when permission to appeal was refused in Cham and Aldred by the Supreme Court, obviously that was a case that at the appeal level also did not raise Human Rights Act points. And did not raise points about the overriding objective for the reasons I've already debated. But notwithstanding that, at that point the Supreme...
So how do we know that?
Well, because those weren't an issue in Cham. Because there was no suggestion.
Sorry, I thought you were saying we knew that they hadn't been raised before the Supreme Court.
Oh, forgive me. I'm simply based on what we... Well, I mean, arguments about discriminating against people by nationality or language would not have been part of the appeal in Cham, because Cham didn't arguably involve issues of discrimination by nationality or language.
They didn't in the Court of Appeal.
No.
We don't actually know what the basis of the petition to the Supreme Court was.
Forgive me, I was just talking about the subject matter of the case itself.
Sorry.
Forgive me if I express myself poorly. I can't say whether or not the appellant in Cham said, the corollary of the Court of Appeal's decision of all these adverse consequences in language cases. They may or may not have made those points. Yes, I was only intending to reflect on, in terms of the actual subject matter of the appeal itself, it didn't directly raise those issues.
No, I mean, the Supreme Court said no permission.
No permission.
But we don't know whether, for example, there was an attempt to raise the sort of points you are... I mean, I've seen what the Supreme Court said.
Yes.
But not...
Yes.
How they were approached. That was the only narrow point I was just trying to...
Forgive me. Well, yes, and as I say, I didn't intend to overstate, and if I did, I apologise.
I'm not saying I want to. Are petitions public documents?
They have just... there's just been a reform about in connection with what Supreme Court documents you can see online. I don't myself know if you can...
I don't think I've ever seen one.
I think they are becoming. I think they're becoming public documents, but they're not anymore. Okay. But in any event, I wasn't. I'm not attempting. The only point I make about the refusal of permission is just as part of the background to coming to the changes in the rules, is that, as the court knows, the Supreme Court did make what, certainly in my limited experience, it's a relatively unusual statement that they're refusing leave, but this. They expressed the view that it should be looked at by the Civil Procedure Rules.
Yeah. The only reason I was just querying is, obviously, if the petition to the Supreme Court simply said the Court of Appeal was wrong but raised no of the additional arguments which you are now saying rendered the Court of Appeal decision per incuriam, if that's the appropriate expression, then that's one thing. If the petition to the Supreme Court raised these additional arguments and the Supreme Court said no permission because you didn't raise them in the Court of Appeal, we're not going to let you raise them in the Supreme Court because for the first time. But we say what we're going to say about the Rules Committee, that's another. And if the Supreme Court, as it were, said that any of those additional reasons that were referred to in the petition didn't indicate that they couldn't be raised but just refused permission anyway, that would be a third.
Yes.
And so there is a danger of trying to read a little bit too much into what the Supreme Court
with
said.
Respect, I entirely agree, and it wasn't. And forgive me for having sort of set a hair. I'm shooting off. My intention is really just as a run-up to the reforms, is simply to remind the court that the Supreme Court had expressed the view the Rule Committee should look at this. I'm not otherwise suggesting that the refusal or a mere refusal or grant of permission to appeal, does not of itself have any impact upon the authoritative nature of the decision of this court. And of course, in recent years, the Supreme Court has said repeatedly that it only takes on essentially matters of a civil procedure nature in very exceptional circumstances. So I think there's a rather lovely sort of apothegm from Lord Hoffman, in fact, in the last years of the House of Lords, where he says this House doesn't normally take on civil procedure appeals, and I paraphrase what he said more elegantly. And when we do, the outcome often tends to confirm the wisdom of the general practice. Is the way in which he expressed it. So there's that. But so forgive me if I if that's been a bit of a distraction. So far as the amendments to the rules are concerned, in our respectful submission, they largely speak for themselves. We have them, again, if it is of more assistance for us to look at them in the white book, then by all means do so, but they are in the authority bundle at tab 6, which is page 82.
But there's no indication that these changes were clearly connected with the decision in Cham or the Supreme Court.
No, that's not part of my case.
No.
No. There's certainly, and as we know from the Judge Cotter, as he then was, report which my Lord caused to be circulated last week. This was part of a much more comprehensive exercise about updating the civil procedure rules to help witnesses with some form of disability or fragility or vulnerability. And the actual, the immediate catalyst of it was the sexual abuse inquiry, and that was the concern. And then clearly, as one sees from that report, it grew into a much more thoroughgoing exercise of revisiting the civil procedure rules. But that was the genesis was in fact the sexual abuse inquiry, and nothing whatsoever to do with Cham or Aldred. But in my respectful submission, irrespective of what the provenance of the reforms may have been, it doesn't throw. I mean, that is in no sense an obstacle if the reforms have the consequence which I contend they have. That consequence may not have been directly in the mind of those who advocated the reforms when they came to be enacted. It's just a question as to do the reforms change the landscape, and our respectful submission is they do change the landscape. And a court that interprets the rule in the light of the overriding objective as it has been revised, in a case where the issue about interpreters actually arises in a way that it didn't in Cham or Aldred, could not now come to the same conclusion, even on the assumption the conclusion in Cham was right as the overriding objective then stood. And so far as it's concerned, I suspect the points are really the points I make for whatever the court's view of them, but the points themselves are probably almost too obvious for exposition. So we have added at 1.1 to the overriding objective, dealing with the case justly and at proportionate costs include so far as practicable. We have the old ensuring the parties are on equal footing. And then we have and can participate fully in proceedings, and that parties and witnesses can give their best evidence.
I think you say, is this right? You say that the court couldn't now, you said, come to the same decision in Cham. I mean, the court could come to the same decision in Cham as regards counsel's fees, potentially.
Yes.
But not in
Indeed.
relation to interpreters.
Indeed.
If interpreters had been an issue in Cham brackets,
Indeed.
which you say they weren't.
It is again this sort of slightly unusual, this perhaps even, well, probably not unique, but this unusual difficulty we have here where the ratio in Cham actually relates to something different, but the reasoning from which the ratio flows, as the Lord Justice himself recognised, obiter, it also appeared to apply to interpreters. But if so it's against that background. But we say a court that's actually, as part of the ratio of the decision it has to make, ask, can you get interpreters' fees? A court asking that in our respectful submission would be driven by the changes to the CPR, even if it wouldn't have been the case before those changes, to a conclusion that 45, well, I'll just call it H as my Lord encouraged, that H should be interpreted in a way which is broad enough to facilitate the recovery of translators' fees.
But this is quite difficult, because if the ratio of Cham is that the claimant lost because the dispute meant matters in issue. If we were to go down the route you suggest, we would effectively be saying what? That the dispute should no longer be so restrictively interpreted.
Yes.
Well, isn't that a collateral attack on Cham?
Well, not in my respectful submission. In my respectful submission, it would be a collateral attack if there had not been a change in the court's own interpretative obligation. But the effect of this rule is it places on the court a new, or at least a stronger, interpretive obligation. Because obviously, again, I don't think we've included it in the bundle, but CPR 1.2, of course, says the court must apply the overriding objective when it comes to interpret a rule, and the overriding objective has now been changed. And so the rule has to be reinterpreted, it has to be interpreted now, when this court comes to make its decision, in accordance with the overriding objective as it has since become. And that, in my respectful submission, means it's not a collateral attack, it's simply a revisitation in significantly changed circumstances. Because, I mean, clearly, these provisions have been introduced into the CPR because it was felt that matters as they previously were unsatisfactory. So it's not just a piece of window dressing, it's to make a substantive change. And therefore, to carry the substantive change to CPR 1.1, the overriding objective, into your lordship's and your ladyship's obligation under CPR 1.2.
But we would have to arrive at an end point which enabled, on the words of H, enabled the claimant, your claimant, Ms. Santiago, to participate fully in the proceedings, but didn't affect the outcome of Cham. Because otherwise you're going to get all the Mr. Chans of the world coming along and saying, or maybe Mr. Aldred, I can't remember,
is Mr. Cham
coming along and saying, well, there's now a different interpretive thing. The court's no longer bound by Cham because you should take this more expansive view.
Well, it certainly is the case, my lord, that sometimes legislation can change the meaning of something which previously had a settled meaning, because it requires the court to apply a new test. And the obvious example of that is the Human Rights Act.
No, but it's one thing to ask us to distinguish Cham. It's quite another thing to ask us to say that in the changed landscape, Cham is wrong, whether by way of collateral attack or otherwise.
Well, I appreciate that this may just be a matter of how I present it for the convenience of my case, but obviously on this part of my argument, I'm saying I'm not inviting you to say that Cham was wrong when it was decided. I'm simply suggesting to your lordships and my lady that the obligation which this court now has, which is a different obligation from the way the court in Cham had, now mandates a different interpretation. So one isn't saying that Cham is wrong. One is saying that you are applying.
But it may mean that even in the changed landscape, as you put it, a necessary part of our decision, if it were to be in your favour, would still be the distinction between this case, which is to do with participating fully in the proceedings, and counsel's opinion, where in fact there are two reasons why counsel's opinion was not allowed. Issue 2 being
issue
resolved.
2 subsists.
But subsists, but issue 1.
It depends, doesn't it, on obviously on the presumption that your lordship is to some extent with me. It really depends the way in which you're with me, because if one, I mean, it would be enough to say that in the particular context of interpreters, which wasn't before the court in Cham, the obligations as they now are so clear. It just requires one to hold that it must be considered now a feature of the dispute that it involves a vulnerable witness or party. That doesn't necessarily mean that that the outcome would be different in Cham, because the opinion, I suppose in one sense it comes from a vulnerability of the claimant in that they're a child, but that takes us back to the point. Yes, that wasn't needed in order to facilitate the access to justice, which is what and the effective you're making your voice heard, giving your best evidence. And that's what this provision, CPR 1.1 as amended, is directed at, and that remains different from Cham. But I am, if necessary, I appreciate that here I might be making a proposition which isn't landing on sympathetic ears. My proposition is it is not a collateral attack in any way on Cham to say that the interpretive rules having been changed, the court now interprets the outcome now interprets the rule differently, because the court's own mandate, the mandate of the overriding objective, that has been altered. And so Cham, it doesn't require one to say that Cham was wrong at the point it was handed down. It is simply that you are...
Well, I'm concerned about Cham going forward.
Yes.
But you're saying, as I understand it, the result in Cham could still be correct, even under the new regime. But it isn't correct. But the reasoning given for the result in Cham has to be revisited and can't stand in light of this new practice direction, because if the characteristic is one which would prevent somebody from participating in the way that is described in the new practice direction 1A, then you shouldn't interpret it as...
in a way that forces the court to not to protect a characteristic which the rule says must be protected.
So it is quite nuanced. The result may not have been wrong and may still be right.
And so the issue, specific issue 2 survives.
But if you're saying you read the characteristic, Lord Justice Coulson's focus on the characteristics of the person as subject to a proviso, which is if the characteristics are such that would prevent them from participating in the process, then his thing has to be caveated.
Yes.
It's not wrong per se, it's just if and to the extent it runs into paragraph practice direction 1A, a vulnerable witness can't participate in the proceedings, then it has to be modified.
Well, my lord, I certainly would put my case in that way, but I however, am not abashed at putting my case more broadly than that, and saying simply that this practice direction does enable the court to say that the proposition that you disregard a personal characteristic of a party, or I suppose it could be a witness, that can no longer be sustained as a broad proposition because of the change of the rules. And that's not saying...
Yeah, I'm struggling to think of an example of a personal characteristic which is one which wouldn't engage practice direction 1A, where somebody might make a claim for an additional cost. And I'm just trying to think what it is. I mean, I'm trying to think of if, for example, there was something which was a cost caused by reference to somebody's personal characteristic, which meant that they incurred it in participating in the proceedings, putting the settlement point aside for 1 minute. But it wasn't one of the ones which is described as vulnerability, let's say, then Lord Justice Coulson could be right. He could still be saying, no, you can't just claim that, because that's down to your characteristics. But where your characteristics relate to vulnerability and your ability to participate in the process on an equal footing, that's where this change, you say, mandates a different
yes.
view. No, my imagination isn't at the moment good enough. Somebody behind you may have thought of one, but...
Mr. Eastwood says that there have been cases where he's been instructed, where he's been asked to make a claim for childcare costs while a parent has attended court, and his suggestion is that wouldn't be that's not something that you would be driven to allow because it was a protected characteristic. But I also see...
So this is an adult participant.
An adult participant that simply had to pay a childminder.
Because I have children and would have to pay for them to be looked after, that's the cost of my participation attending in court. But it's not something which, it's not driven by vulnerability. And therefore, practice direction 1A would say, well, Lord Justice Coulson has said it's nothing to do with the dispute. You just happen to have children.
Yes.
And you can't recover, therefore, and nobody's access to justice is, in this sense, is interfered with because they have children. Yeah.
Yeah, I mean, okay. I'll do some more thinking about it myself, but
well, that's good enough to go.
It's pretty close to F and G.
Well, that's why I was a bit
Yeah, okay, but
circumspect about it.
It's of the same sort of character as F and G.
but yeah.
Yes.
Okay, well,
Mr. Eastwood's example.
Yes, that's why I was.
Mr. Williams, can I just pull the threads together? On your case, are there therefore two ways you would suggest for this court to approach it? The broader way would be to say that the interpretation of H adopted by Lord Justice Coulson, although it might have been right at the time, is no longer sustainable in light of the changes.
Yes.
And it goes completely, and that deals with all of these
Yes.
examples, and everybody starts again when
Yes.
they look at H. Alternatively, you'd say we don't need to go that far. There's a narrower way of doing it, which is to say that Cham wasn't dealing with interpreters,
Yes.
and that in light of the changes, on any view, whatever Lord Justice Coulson said, it has to be read subject to a caveat to the extent that the individual's characteristic goes to access of justice. So that gets you home on, you'd say, on interpreters, but it leaves the world open to Cham too, because there would then be other questions about other
Indeed.
sorts of disbursements and how you're going to...
Indeed, and I mean, I'm not appreciate it's not sort of necessarily what's underpinning this debate, but also you can't just reopen Cham because of this freestanding point that that was issue 2. That you couldn't get the cost of the opinion because it's deemed to be included in the solicitor's fixed costs already. So which is obviously so it's got nothing to do with interpreters, because you can't possibly suppose that a solicitor's fixed costs covers an independent interpreter being paid to attend court for a day. But my lady, with respect, yes.
But that's a third way of looking at it, saying all Cham decided at its limit was what you do with counsel's advice in because of this point 2 business, because
Yes.
that's covered elsewhere and it has nothing to do with any other disbursements.
Yes,
Which
but I would have to accept that. Obviously, one of the first things I considered was, can I say that the ratio of Cham is issue 2? And I don't think I clearly can't. That wouldn't be. If Section 3 of the Human Rights Act applies to judgments, I might be able to, but it doesn't. So I can't put it quite that high. But your ladyship, if I can respectfully say, is quite right to say I can put my case certainly at the broad level and the targeted level. And I think the proposition my Lord Justice Snowden put to me a few moments ago was very much if I can respectfully say so, a very clear articulation of the targeted level. But I did want to make clear that I do maintain, for good or for ill, the broader point as well. It's not a question of saying that Cham is wrong. It is. I appreciate this will seem like a hopelessly semantic distinction. It's not saying it's wrong. It's saying it's no longer right. And the reason it's no longer right is because of the palette from which this court paints has changed in a fundamental respect, because what's more fundamental than an adjustment to the overriding objective itself, which CPR 1.2, which, as I said, isn't in the bundle, but I'll just read it out because it is so clear, Lord Justice Coulson doesn't mention it. The court must seek to give effect to the overriding objective when it exercises any power given to it by the rules or it interprets any rules. And that's just subject to some cutouts about counter-terrorism legislation. So it is the sort of fundamental interpretive exercise, and the court must seek to give effect to the overriding objective when it interprets any rule. And that, in my respectful submission, is the answer to the understandable fastidiousness of my Lord Justice Stuart-Smith. It is not a collateral attack on Cham. It is simply saying this court has to discharge its duty under CPR 1.2 to give effect to the overriding objective. Having regard to
1.2 was always there, wasn't it?
which is always there, but the overriding objective has changed.
I know.
Yes.
I mean, the narrower approach has this point in your favour, which is, you said earlier, it's a little bit odd to think that somebody like Lord Justice Coulson didn't have the overriding objective sort of, written in like a stick of rock,
Yes,
in letters, down the
Calais
middle.
on the heart of Bloody Mary, as she said. Yes.
But with fairness to him, he couldn't have had in mind the overriding objective as modified after he'd given the judgment, focusing particularly on the ability of people to participate fully in proceedings and giving best evidence, because that wasn't expressly.
Yes, and I think that goes back to
and in a sense, but because the particular case that he was dealing with didn't force him to focus on that question of participation and giving your best evidence, whatever, because it was all to do with the counsel's opinion to settle, it's sort of understandable, you'd say, why he wouldn't have framed his test in a way which, had he now been sitting here, he would have caveated or put a proviso on it.
Well, my Lord, with respect, absolutely, I absolutely do say that, and as I think your Lordship was really just but much more crisply something I said earlier, that in an ordinary case, one would say, this isn't a statute. Of course, the judge must have had all this in mind. It's absolutely, it's Civil Procedure 101. But there is an explanation for the learned Lord Justice not having it in mind, which is the explanation which your Lordship has just articulated. He ultimately wasn't dealing with a point that went to sort of fundamental issues as to being able to participate in the proceedings, so the sort of fundamental point of being able to understand what is going on, understand the questions which are put to you, and being able to give an answer to which the judge can understand. And in the translating that into the language of the revised overriding objective, equal footing, that's always been there. Participate fully in proceedings and give their best evidence. And in my respectful submission, that is enough to say that insofar as we're dealing with the interpreter scenario, that even if Cham, whatever might have been the case when Cham was decided, it is not the case now. It's perfectly clear from the points that my Lord Justice Stuart-Smith put to me that the practice the contents of the practice direction that supplements these changes to the CPR is already very well in the court's mind. Simply so that's, but just for completeness, that is at page 84 of the bundle, same tab, and we've put marginal lining to the passage we particularly rely on. The court is warned of vulnerability impeding participation, diminishing the quality of evidence. The court should take all proportionate measures to address these issues in every case. And then at 4, vulnerability factors, communication and language difficulties are specifically identified. And 5, the court is enjoined to consider a party's or a witness's ability to understand the proceedings and their role in them, to express themselves throughout the proceedings, to put their evidence before the court, to give their representatives instructions to attend any hearing.
I mean, you can make, but you could make your point without reference to 1A, simply by reference to 1.12A as now amended.
Yes.
Speaking for myself, I struggle a little bit to see your client as being a vulnerable witness in terms of what you normally understand by that.
Yes.
He had language difficulties.
Yes.
And normally, I mean, it goes back to a more fundamental point about access to justice. You wouldn't see that as a vulnerability, that it required special measures, because the ability to communicate is sort of part of the ordinary package.
It's
Yes.
except that in the report, which you say was Barry Cotter's, as he then was, they do refer expressly to vulnerability in the context of being unable to explain or understand what is going on in court.
Yes.
I mean, I haven't got the reference at my fingertips, but it's definitely there.
Well, so, I mean, if I can firstly respond to my lady, obviously what my lady puts to me is quite right. The label of vulnerable witness isn't something where one would automatically assume one's talking about English as a foreign language. For example, but that's a label which is being used, I suspect, in large measure because of the original provenance of these reforms, which, as I've said, were rooted in victims of sexual abuse. But it's since been broadened. And so far as the point that my Lord Justice Stuart-Smith has put to me about the report, I mean, where I would submit the report is very useful. It's an extremely thorough exposition of of various preparatory sources, travaux préparatoires. Reports by international bodies, interventions of charities, campaigning organisations like Justice and so on. And in our respective submission, they all speak with one voice. I mean, what is underpinning all of this is a concern that the court has to take measures which are more proactive than they used to be to ensure that the voices of parties and witnesses can be properly heard.
I think this is, in a way, this is semantic. I mean, if Mr. Simon Brown, King's Counsel, didn't understand and couldn't speak English, his side would be at a disadvantage, and in real sense, he would be vulnerable because he would be sitting there not knowing what on earth was going on. So I don't think we find the answer to this question in a definition of vulnerability or labels. It's fair and square. It's an access to justice question.
Yes.
I mean, my only point was that, in fact, you don't need to dip into the section headed vulnerability. You can make the access to justice point simply by reference to the wording of
the rule
1.12a, which talks about participating fully in proceedings and the parties and witnesses can give their best evidence.
Indeed.
So something relating to somebody's personal characteristics is generally irrelevant for the purposes of this rule about cost recovery, because it doesn't relate to the dispute, save insofar as it is a characteristic which would prevent somebody from participating fully in proceedings or giving their best evidence. It requires a disbursement of a recognised type to address that.
Yes.
Of which an interpreter for somebody who doesn't speak English, which is it's a characteristic, but it's not forefront of your mind in terms of vulnerability. It's just I can't speak French, but I appreciate it might put me at a disadvantage and make me unable to participate in French proceedings, but I still probably wouldn't think I'm vulnerable. So, we just don't need to go to the label vulnerability.
Yes. Well, I don't disagree. With respect, I don't disagree with any of that. But if one does go, you do in fact see that the way vulnerability is expressed, it actually would encompass in our submission the facts of this case. But as your lordship says, really, and also rules, not practice directions. It's the overriding objective, as amended, which obviously I place my principal emphasis. My lords and my lady. Obviously, as my lord said, I'm not just going to rehearse what's said in my skeleton. There are a few points in my skeleton I haven't picked up. I'll take those as read, so those are my submissions, unless I can assist the bench further.
No, Mr. Williams, thank you very much indeed.
Thank you, my lord.
Mr. Eastwood, do you want to follow?
No, thank you.
Mr. Ryan?
My lady, may I approach this in two ways, really, before descending into the granular argument that's been had over the precise wording. Just take you back to what Mr. Williams says is irrelevant in this case, but we put at the forefront of our case of the nature of the scheme. He suggests the swings and roundabouts is irrelevant, but you have two authorities before you that explain the very nature of these swings and roundabouts. You've got Lamont and Burton in your file. The relevant passage is marked, and you can go there as to the very nature of swings and roundabouts, but also as something that featured in the judgment of Mr. Justice Coulson we were looking at present in the case of Cham. And in particular, if I can take you to paragraph 56 of Cham. In the bundle, it's actually at page 336. And in paragraph 56, he talks about, really, he's on for 55 as to the items of work that seem to be within the fixed costs. He says, in reaching a conclusion, I bear in mind Mr. Manning urged me to do the observation of Lord Justice Briggs in Sharp and Leeds City Council of 2017, which he stressed the comprehensive nature of the fixed cost regime, a small category of exceptions, and the fact that there are inevitably swings and roundabouts as there are in any regime designed to deal with high bulk, low value claims. The fact that this additional cost will be necessary in some claims and not in many other claims is simply another example of that process. And the words I used in my skeleton, I think in paragraph 25, about there being more profit in some cases, less profit in others, but particularly as long as the approach of the solicitors was in pursuing legal business was profitable overall. I cribbed those words from the report of Lord Justice Jackson, as then was in the second report, when he's dealing about the fixed cost regime. And there are bound to be some cases that are more expensive to run for a solicitor, where the profit margins are less, and there are going to be other cases where the profit margin is more. For example, if they don't have to pay for an interpreter. But the fact of the matter is that these are profitable costs in this regime, and there are some cases upon which the costs are more expensive, and some cases on which they are not. And that makes sense as we go through the whole civil tiers we have of small claims tracks, fast track, multi-track, and of course we know on the horizon there's a new one called intermediate track. But proportionality came in with aplomb in 2013 from the report of Lord Justice Jackson, as he then was. Now, Sir Rupert was clear to bring in the highlighted proportionality, and there is a reason for this, and the fixed cost cases were driving, or came from the driving forces to install proportionality, that as you go higher up the tiers, the costs will be more reflective of the damages obtained, and the tiers are aligned directly to the damages claimed or awarded. And as you go through, the cost recovery is going to be greater. And there are deliberately measures, cuts and allowances as you go through that are more generous in the higher tiers than there are necessarily in the lower tiers. But at the end of the day, it's our position that even in the lower tier, where those restrictions may be more imposing on solicitors and clients, there's no preventions to access to justice whatsoever. It's perhaps important also, just to page 106, or rule, I direct your attention to Rule 44.1. It's actually page 106 in the authorities bundle. But Mr. Williams is making a great deal of, well, solicitor is allowed his profit costs, but he has to spend money on other matters. At page 106, you have the definition section, really at the commencement of all the cost rules in the CPR. And the definition of costs is in the second half of the page. And it's the first of 6 words. Costs includes fees, charges, disbursements, expenses, remuneration. And that's the definition of costs. For every cost lawyer or cost draftsman, every those practicing costs refers to. It is all inclusive, and these are the fixed cost rules. They include all those matters within the rules.
So the question is very simple and in 2 halves. One, may it be said that, as was said in issue 2 of Cham, that this disbursement is within the fixed costs, in which case it wouldn't be recoverable because that's double recovery. And 2, do the rules justify the separate recovery of the interpreter as a disbursement? Because there's no doubt that despite that definition of costs, there are some disbursements which are separately claimable. And the only issue for us, it seems to me, generally, is whether on a proper interpretation of the rule, this disbursement is recoverable. Full stop.
Yes, safe to say, on the lead question that has been troubling this court this morning, and very much the core of Mr. Williams's argument is, if you don't interpret it as recoverable, it's going to restrict Mr. Santiago's access to justice.
Yes, but not interestingly enough, not in terms of cost, but in terms of ability to participate.
Well, that's exactly my position, my lord. It's not in terms of cost, because the solicitors will take these cases on. And can I just emphasise, and this will be
that's not quite what I meant.
I beg your pardon.
Right.
I don't want to put words in your mouth, my lord.
No, well, that's right. I can look after myself more or less.
I've heard. But my lord, the fact of the matter is that people in a position that there's no evidence before the court that people are not going to have access to justice denied because they are a foreign language speaker, because the costs are not going to be recoverable either overall in the money that the solicitor gets, or, as Mr. Williams would have it, they should be paid separately and in addition to what they're going to get anyway. It's just not the position in this case, or it's not the position in this scheme. And the reason I say that is because, and it's important really, that for 2 reasons, that this argument we're having only goes to cases where we are dealing with cases that go to trial. 3A is where they are going to trial. That's important for 2 reasons. When I come to look at the words dispute with the court, because the court's going to know what is in dispute, even if it settles at the door of the court. The court would have read the pleadings, etc. So when we're looking, just to forecast what I'll be saying, but when we're looking at claim and dispute, the claim can be wide-ranging to start with. By the time, in these cases, we get to trial, we know exactly what the issues will be and what is in dispute. But more importantly, for my current submission, when the court receives this case for trial, even if it settles at the door of the court, full trial fees are recoverable. And what that means for these solicitors is, in your authorities bundle at page 142 within the rules, it's there behind tab 9, going straight into 3A. In the middle of the page, table 6B is where we're concerned with. And there are 3 stages where the claim no longer continues under the protocol, i.e. it comes out the protocol and is going towards a trial, and may settle beforehand. A is if they reach a settlement prior to issuing proceedings. B is if the proceedings are issued but the case settles before trial. Or C, with what we're concerned with, the claim is disposed of at trial.
No, it was disposed of before trial, wasn't it?
So
They would
C
be
is
gone for trial.
yes, and C is over the page, milady, is the claim is disposed of at trial. Now, the reason this case was disposed of at trial, because of the case that's mentioned by Lord Justice Coulson and is in the authorities bundle. It's a strange thing. It's a windfall for counsel that you turn up at the Leeds County Court, you settle at the door of the court, and the Court of Appeal decided that you're entitled to your trial fees. That's the way the system works. It's just rubber the green for the defendant, probably.
In fact, Lord Justice Coulson's case had to settle at trial because you actually had to have the court. I mean, it's difficult to understand how the court would otherwise approve the settlement.
Oh, well, that's, yes, that's...
I mean, how does that work? Sorry, that was a very bad question.
No, I understand what you're saying.
If the court is asked to approve the settlement on behalf of a child,
yes.
Is that a settlement at trial, or is that capable of being done prior to trial?
No, I would submit that's prior to trial.
Right.
But I'll think on that if I may.
Or it could be at trial as well.
It could also be
if
at
you
trial.
do it at the door of the court, yeah.
Yes.
You would engage the judge who assigned to the case.
Yes.
Yeah.
And you
But
probably
one way or the other, if you settle either temporarily before trial or on the morning of trial, because it's a settlement, it's because it's a compromise, you need counsel's opinion to go before the court in order for the court to endorse the settlement.
if you're a child, yes, or a protected
Well,
party.
we're talking about Coulson.
Yes.
We're talking about Cham.
Yes, if you're a protected party, yes. And indeed, that can be done, one would say, verbally, as indeed the court's far more familiar with the larger catastrophic settlements where you come for an approval hearing to be dealt with orally at that time. Yeah.
But in those circumstances, it's not relevant to these cases.
No, but what is relevant?
But there you would typically have a written opinion, and because of the importance, whether it's an individual or a multi-party case, counsel on both sides will turn up, or counsel on one side will at least turn up and say, I've endorsed this.
You'll often get both sides turning up.
Yes, because the court may say, well, hang on, what about this?
Absolutely, and they do often. But in this case, or in these cases, when we're looking at access to justice, if you look at C at the top of page 143, what the solicitors will get in taking a case to trial is they get a profit cost fee of 2655. They then get 20% of the damages agreed or awarded. Well, in this case, we know the award is £20,000, so they're going to get £4,000 extra profit costs. And then you get the relevant trial advocacy fee, which is in the table below, D, directly below, and on the right-hand column, because this case is more than £15,000, there'll be £1,705 the trial advocacy fee. Doesn't have to be counsel, it could be solicitor advocate. But the fact of the matter is that to say, let us take Mr. Santiago in this appeal as an example, if H is interpreted narrowly, as was done by Lord Justice Coulson, he will be denied access to justice, is a fallacy. The solicitor has £6,655 profit costs alone to pay an interpreter, and they do. And there's a number of other disbursements they will reclaim, but the one they're not entitled to reclaim, the one that the argument is over, is £924 in this case for the interpreter.
But hang on. Running up in the day or two before the hearing date that's fixed, when you don't know by definition that there's going to be a settlement at the door of the court because the insurer is still saying we're not paying, or we dispute the amount, or whatever. If you ask the question at that stage, what will it require to enable Mr. Santiago to participate in the proceedings and to give his best evidence of how the accident occurred? You would say he will only be able to participate and have access to justice in the sense of being able to understand having his evidence understood by having an interpreter engaged, which will happen naturally a few days before the hearing. You have to make a booking with somebody to come to court. So you ask the question a day or two before court, the hearing, the settlement, what is required to enable Mr. Santiago to have access to justice, i.e. have his evidence understood by the judge so that he can get a judicial decision on his case.
Yeah.
He will need to engage the services of an interpreter. So if you ask the question in terms of is an interpreter required to give him access to justice, the answer surely is yes.
Yes.
Right.
An interpreter is required, and that solicitor is going to cover that in his profit costs. Even if he settles at an earlier stage, he still gets, if it's the B, the case settles before trial, on or after the date of listing.
Right. Well, but the question of where the disbursement falls is, I appreciate the reason why we're here.
Yes.
But if you ask the question, is that disbursement one which was necessary to give him access to justice when it was incurred, then the answer is yes. I mean, obviously, if you know you're going to settle and you haven't engaged an interpreter, then the engaging of an interpreter would not be required to give access to justice because you would know that he wouldn't have to give evidence.
Hmm.
But if settlement occurs at the door of the court, he did need that disbursement paid in order to give him access to justice. Then the separate question is, okay, where do the rules say it should fall?
Yeah.
But it is an access to justice issue, isn't it?
Yes, I accept it's an access to justice. I accept two things. It's an access to justice issue, but it's not actually an issue, we say. It's access to justice has to be recognised. Secondly, it should be an independent interpreter. Because I think you're aware, my lord, my lady, that in this case they have an in-house Portuguese interpreter who dealt with the witness statement. And that was covered in the witness.
Right. That was, for the reasons we explored, but that person couldn't have been engaged to appear at trial because the order which we've seen said, no, it had to be an independent interpreter, for fairly obvious reasons, actually.
But in our submission, my lord, I'm not sure if, even if they settle prior to engaging if they settle prior to trial and engaging an interpreter, they still get their 2655 and they still get 20% of damages.
Right. But the point is, that's right. And if they're stupid enough, having settled and knowing that all they need to do is to go to the court and put the counsel's opinion in front of the judge to get the formal court sanction to settlement if it's a child, for example, if you go ahead and, for example, engage an interpreter for a trial that isn't going to take place, of course you won't get it because it's just not reasonable anyway. But
it's a business model there. If you are encouraging Polish people, Portuguese people, whoever, you know, and some cases may not succeed at all. It's again, that swings and roundabouts, no win, no fee. But the fact of the matter is, you are on the ones you win, and this is all to do with recovery of costs. Does it deny the claimant access to justice because this particular part of the cost recovery is not sustainable because of Cham? And the answer is no, it doesn't deny them access to justice whatsoever.
It might make it a much less attractive prospect for the claimant's solicitors, though, mightn't it? If they know they've got to soak up, if it goes to trial, they're going to be likely to have to absorb £1,000 out of their profit costs. I mean, on these sorts of margins, that's quite a lot of expenditure, isn't it?
There is no evidence of that, my lady.
No, but I mean, we're all sitting in the real world, aren't we?
But there's no evidence.
Well, in the real world,
there's no evidence, if I may say so, of the idea of this claimants firms going around shopping for Polish or whatever claimants. I mean,
no, except we know this particular firm had a Portuguese person in house to deal with this.
So they might have done, but what if somebody who spoke a different language?
Well, if we descend to the real world, no, I'm not going to, because I have instructions of Mr. Howard Dean behind me as to what the market is like. But the fact of the matter is, dealing strictly with the rules, this is the swings and roundabouts. This is some you win better, some you lose better. If you choose to take on a foreign national or a foreign-speaking person who may be an English national, if you choose to take that case on, it's still profit margin there.
Yes, but that's the point, actually. If you choose to take that case on, you're going to have an additional cost to bear at trial if Cham's right across all aspects. So that's the disadvantage. I mean, that would seem to me to make a difference between the way you treat people who do speak English and people who don't speak English.
Well, they have their right to turn clients away and say, I'm not dealing with your case, but it's an access to justice here is to, in principle, is the cost covered by cost recovery? Yes, it may not be specifically covered to the tune of £500, £700, £900 by recovery from the other side, but there is money awarded by going to trial. And that's what I emphasise. This is only when you go to trial or you're leading up to trial, when the trial's been listed, you are taking 2655 plus 20% of the damages. And therefore, there's no access to justice query here.
But why should the rules, why should the rules be interpreted in a way which provided some disincentive to solicitors to act for people who would require interpreters at a trial? I mean, it may be you say it's a small disincentive and they can just suck it up as part of the win some, you lose some. But why should the rules be I mean, that's a matter of evidence as well.
No,
we don't have out either. But why should the rules be? Why should the rules be interpreted in that way so as to run that risk, if you like, of solicitors saying, "Look, these are fine margins. It's just not worth our while taking on non-English speaking clients, because we know our profit margin will be reduced by the need to have an interpreter at the end of the day. So it's part of an overall equation. We're just going to take on English-speaking clients." Now that's an unusual interpretation of the rules that probably has all sorts of problems about it, doesn't it?
Well, I want to develop the argument there actually when it comes to vulnerability, because in that document you kindly provided yesterday from this court, they specifically deal with Aldred and Cham. And that vulnerability there isn't actually a language vulnerability. They've actually taken that. I'll come to that. The cost provisions on that vulnerability point are not there. So that's another point back in my case.
I'm not. Let's not go down the vulnerability rabbit hole. It's simply on the question of somebody who needs an interpreter to give his evidence at a trial. That's all we need to know. He can be a very sophisticated person, but he just doesn't speak English. He was visiting here from overseas on holiday and got into an accident. Very sophisticated person, but will need to come and give evidence in a language which is not his first language. Why should the rules be interpreted in a way which disincentivises solicitors from taking his case on?
Well, that's got a loaded question, my lord. But
it is. I'm sorry. I'm just putting. Of course, it's loaded. I'm putting the argument
I'm here to
against
deal with it.
you.
Because the fact of the matter is, in my I think in my skeleton, I said the rules committee could only go so far as to what disbursements could be allowed, because disbursements. Ask anybody in a room full of personal injury lawyers, I suspect, what a disbursement could be. They'll all think of another disbursement. The list could run forever and still some disbursements would not actually be covered. Therefore, it's a catch-all at the bottom, particularly if it is, and it's the words we're going to have to look at, possibly after the short adjournment, but it's a catch-all as to what other disbursements there may be. Now, it so happens it's been interpreted the way it's been interpreted. We say correctly, for reasons we'll come to, but actually, the learned friend, right at the beginning of his skeleton and throughout the argument, has said it's an access to justice point. And in paragraph 10, must have been written by Mr. Williams because the tone of the language of the way he said it in his skeleton. If I can just bring it up, it's
Is this your reference to naked? Naked.
nakedly unjust.
It sounds like Mr. Williams.
I think it must be. Though Aunt Sally doesn't.
Although,
do it,
in fairness to
normally
Mr.
don't.
Eastwood, you say this bit must have been written
Paragraph 10, that yes, just
by
what am I
Mr.
looking
Williams
at?
as
paragraph
opposed to
10
the
of
whole thing.
Appellant skeleton argument, lady. The first complaint is that the claimant will incur irrecoverable costs. Well, that's the nature of litigation, I'm afraid. We know no one ever gets all of their costs back. If it so happens that the rule and interpretation of the rule by this court, it's in the bund list tab 2, in the core bund list tab 2.
I've got it, yeah.
Oh, sorry.
I'm just looking at my highlighter, which you can't help me with, I don't think. That's fine, I've got it.
Yeah, but hang on, you can't. It will incur irrecoverable costs despite the costs being essential. I mean, of course, there are irrecoverable costs, which are. The actual argument is these are essential.
But he's not actually incurring the irrecoverable costs. The solicitor, but to gain the business, where the business is profitable overall, is playing on the swings and roundabouts as to which parts of the business can be profitable. Some may be less profitable than others, but it's not the claimant who himself is incurring. It's not Mr. Santiago. It's not the child who is incurring irrecoverable costs. It's the solicitor on their behalf getting the case to trial.
Right. Yeah. Sorry, that's a different point. Yeah, which is fine.
And B, they say the claimant will, at best, will have to fund those costs out of their damages, in which case damages will be depleted. That's not any evidence here at all as to that, or how the way the system works. So again, that's not fair to say that is denying access to justice.
Just going back to what you were showing us earlier, the 20% uplift in costs, the 20% you take out of the damages, that's a fixed amount, is it? So
No, it's not taken out of the
No,
damages.
it's not saying that the damages.
You get 20% of the sum of the damages
Got it.
as part
Sorry.
of your costs.
You can then put it on your
And that's
cost
an
bill and claim
automatic.
it back. The cost bill here was something like 13,000 because you had a lot of other disbursements and medical reports, etc.
So the real, and I'd missed it, and I apologise. Your real objection to 10A is that it's not the party that incurs the irrecoverable costs. It's the solicitor that has to recur disbursements which they will not. Yeah. That's how you're saying it. Really.
Now, any cost law here will tell you that the cost of the party's costs and the party's responsible for those costs. But in reality, it's the solicitor in reaping the profit costs of 2,655 plus £4,000 in this case.
And that's because the arrangement between client and solicitor will undoubtedly, in this sort of situation, be, is this right? The solicitor will get the fixed costs, and there won't be any recourse to the client.
We don't know what the absolute agreement is. Some solicitors may want to make deductions, some others may not. But the fact of the matter is, it's not stopping them taking the case to trial.
Well, actually, but this is the point. I mean, if the client is at risk of having to reimburse the solicitors for costs which are not recoverable, then it could be an access to justice point because for the client, because it would be a cost to the client who may not be able to afford it of taking the case to trial.
Well, yes, but in reality, my lord, there are always going to be irrecoverable costs. A solicitor may get back 6,000 on the case and he spent 8,000. Maybe a matter between him as to what damages he recovers if he has any share of those. But the fact is to say that is an access to justice point to deter him from going to court. We say that the whole fixed cost regime here is to enable keep the cost down to going to court.
Speaking in terms for myself, this win some, lose some argument, although in one sense clearly and undoubtedly right, that some cases will be more profitable for a solicitor than others, doesn't inform the issue we have to deal with at all. Because the issue we have to deal with is whether the cost of an interpreter is recoverable. It's a common ground that it's only recoverable if it can be brought in underage.
My lord, yes. I was hoping to distinguish my submissions as to the overall working of the scheme before turning to the
Okay.
granular detail. Because I think that certainly Lord Justice Snowden earlier was talking about the general market forces and the costs here, and also with regard to at the centre of the learned friend's submissions is access to justice. That Lord Justice Coulson did not have this in his mind, and particularly the rule 1.1 and the practice direction 1.2a, and that access to justice is a driving force here as well. So I was dealing with that element first before I go to the granular detail.
Okay.
Oh, by all means, I will be seeking to uphold the judgment of Lord Justice Coulson for a number of reasons, but I was dealing with this matter hopefully conveniently before the short adjournment. So because we say it runs through. If there is no problem with regard to access to justice because the money is recovered, or costs are recovered, but they may not be recovered as much as they want to be recovered, it actually defeats the overriding objective argument and it defeats the HRA argument, because there is access to justice for somebody who speaks a foreign language. That's why we say it's fairly important in the scheme of things. So if your Lordship bears with me, I'll now get to the point that I want. The third element, they're talking about defendants they have to self-fund interpreter charges, come what may. Well, my Lord Justice Snowden referred earlier to the particular passages with regard to 40. Bear with me. I'll precise place where you're referring to. It's 40. I'll go to it just to take you to it. Basically, in the authorities bundle, where we're looking particularly with regards to the provisions we're dealing with at this section. We are dealing with, bear with me, 4529I, it's 4929F, that a defendant can recover their costs if they are successful. That's at the bottom of page 146. Now, those costs are limited to what a claimant could recover from a defendant. So we don't accept the argument here as to access to justice with regards to defendant. Nor do we accept paragraph D in the skeleton as to them being gravely disadvantaged, because there are funds to pay for those costs. And the solicitor may not end up at the end of the day with those funds. But the fact of the matter is that these are cases going to trial, and this is the advantages to a solicitor going to trial and advocacy fees included as well. The costs are being paid, and therefore we say, although the £924 in this case, which has question marks over with agency fees, etc., but the fact of the matter is between £500 and £900 will be covered by the costs covered. And therefore the access to justice argument, we say, is not a valid one. That takes me, I probably can deal with it quite briefly. I don't aim to be long in my submissions because it may be longer after sort of general with regard to the interpretation point. But also, if you have the document that was produced yesterday with regard to vulnerability, that Mr. Williams is on one of his limbs of argument, saying, well, times have changed since we've had the new rule. If you have the document that was produced yesterday by this court,
Give me a second to get it.
this is the Vulnerable Witnesses Party's report,
Yeah,
final report.
I just didn't print it out, so just give me a second.
Mr. Brown, if we have just 30 seconds, can I go back to an earlier point? And I'm sorry if
Yes,
I just
of course.
missed something on the papers, but I was looking at the fixed costs,
Yes.
and it's just a niggle, I just want to understand it. It does talk about 20%, part of their fixed cost being 20% of the damages agreed or awarded.
Yes.
But I understood from interventions that the cost, it's 20% valued by reference to the damages agreed or awarded, but it looks like you do actually, the solicitors do get a chunk of the damages to me.
Well, I'll take instruction.
That would make sense, because wasn't there all that case law about uprating the general damages to accommodate?
Can I turn my back on you later?
And over lunchtime, it doesn't need to happen now, I just want to know.
We'll inform the court.
Right, I'm now there.
But I mean, just I'll come back to that.
Can you come back to
yeah,
that?
I
It's
can
just
see
a
it.
niggle. I don't think it
My Lord,
affects this case, I just
on
want
that
to know.
document, in particular, page 53 on my document, we have, at the bottom of page 53, we have a specific section on interpreters.
So this is the internal pages, yeah.
Internal pages, page 53.
Thank you.
At the bottom of the page, paragraph 118 of the document. In fact, it's very short, well, for good reason, which I'll explain, I forecast in a moment. But 118 and 119. And if I can direct the court's attention to the footnote, number 128 at the bottom of page 54. If the party pays to an interpreter for translation services, costs incurred or ordinarily recovered as disbursement, subject to the wording of any applicable fixed cost regime. See Aldred and Cham.
Sorry, what's the point?
Footnote 128.
Yes, yeah, but I can read it. Sorry, what's the point?
Well, the point is, so when I, in your authorities bundle at tab 5, you have the practice direction update arising from the amendment to the overriding objective. Not only do they state the overriding objective in its new form, but they provide rules for cost recovery of enabling the overriding objective to be met, except dealing with the costs for provisional work or expense towards the overriding objective are not in the rules for the fixed recoverable costs.
Where are you looking at? Sorry.
Page 75 of the authorities bundle, where there's a summary of the case. And I can provide to you, after the short adjournment, the precise rule where it states these are coming into force following the Civil Justice Council's report. And the final 9 lines, my lord, on page 75.
A bit of a technological glitch. What page are you on?
Page 75 of the authorities bundle. So not only does the amendment make clear dealing with the case justly includes ensuring parties can participate fully and that parties and witnesses can give their best evidence, it also deals with costs, not fixed recoverable costs, provision for additional work or expense occurred due to vulnerability of a party or witness. And I will provide you with the precise rule where, because of the acknowledgement of Aldred and Cham, because of the report that was the basis of these amendments, when this was implemented in the Civil Procedure Rules amendments, although they provided cost provisions for vulnerable witnesses generally, they cut out or hollowed out the fixed cost regime and didn't amend those.
So you're saying that we should read back from that the changes to the overriding objective were not intended to apply to the fixed cost regime?
Yeah. But the cost recovery, not intended to apply to fixed cost regime.
Well, I understand that the cost recovery provisions are not intended. What they're saying here is, for vulnerable witnesses, we've made specific cost provisions which relate to costs generally, but not the fixed cost regime. But that it doesn't follow, does it, that the overriding objective isn't the same for the fixed cost regime and the
No, I'm not saying it is, but I'm tying this in with my former argument that actually cost recovery is still enabled in that case, and it has to be met out of that in the swings and roundabouts approach.
Okay.
But it's right the court has the history of this, because I referred, I think, to the vulnerable witness report, and you kindly provided it. I've got a couple of things more to say about it, but I know at the time I'm in the court's hands.
But if you've got, what is it, 5 minutes?
If that.
Do you want to finish that?
Yes, I will.
Finish this section.
Just on this document, this is I think we're all used now to vulnerable witnesses, having been educated over the last few years, particularly those who see it, those who practice, as to deal with. And I think the criminal bar has been leading the way, and family courts have been leading the way as to how to deal with the vulnerable witnesses. What is quite particular about this report is that a quick word search of language in here only produces 7 results, and each time, I can give the court the page reference numbers later, don't need to take time up now, or paragraph numbers, but in each case it's talking about the use of the court language, it's talking about procedural language, and, bear with me, clarity of language and unfortunate legal language and complexity of language. This report as to vulnerability, particularly with this separate section as to interpreters, is to be seen, it's not actually talking about vulnerability with regard to inability to speak language. The background to this is very much driven to vulnerable persons because of the court process, being able to deal with the court process in its language, not necessarily with interpreters and their foreign language, which of course is why it has that separate part therein. So the reason I raise these things is part of Mr. Williams's plank, just in conclusion here, is that times have moved on from Cham as to these amendments we've had. And undoubtedly there are amendments, and I don't try and say to this court fixed costs can be so remote that nothing applies to them, but there are particular provisions for the fixed costs as to why his argument is nowhere near as strong as he would say, because the way that rule has developed and the fixed cost regime costs have been carved out from those amendments.
Yep, and that might be a moment to stop, but speaking in time for myself, page 75, the bit of brackets, not fixed recoverable costs. I'm not quite sure how that works its way through.
I indicated to the court I will produce the relevant, of the short adjournment, take you to the relevant rule as to where it's dealt with.
Okay. Would 2 o'clock be all right?
Perfect.
Thank you very much.
Court rise.
What do you say is the